Interim orders
Items?
are there. 22 to 24,
All right. CD not received. List again on. Any interim? Interim order passed earlier to continue till the next date of listing.
May I please proceed? I beg to mention item number 18. Earlier occasion TCR was called for but not yet come, my lord.
There is some office note, I think. Anyway. CD or TCR? CD.
TCR.
TCR.
That case.
Here is call for has not been received. Issue reminder. List again on. Yes.
Obliged.
May I please also? I beg to mention item number 19, my lord. TCR has been received, my lord. We need to go through, my lord. Can it be after 1 week, my lord?
The prayer of learned counsel for the matter.
9 Obliged, my lord.
May I please, your lordship? I beg to mention item number 28, lordship. City has not received, lordship.
28. It did not receive list.
Interim may continue till next day, lordship. Obliged.
May I please receive? I beg to mention item number 9.
9.
9, my lord. Kindly pass over for the day, my lord.
List again on.
Day after tomorrow, my lord. Day after tomorrow. Obliged. Obliged, my lord.
May I please, your lordship, I beg to mention item number 48 of the daily list, my lord. And matter may be adjourned for the day, my lord.
48, 49. List again after.
Much obliged.
Yeah, please, lordship. I beg to mention item number 33. I am praying for adjournment. 33.
CD not received.
Did you know this?
Not received.
Kindly fix Tuesday.
There was a 9. Technically 10th.
Yes.
10th February.
Lordship, I beg to mention item number 50. In the list after 3rd March.
Prayer of learned counsel for the petitioner. In on.
Obliged. May I please, your lordship, I like to mention item number 40, CD call for it is not received. Matter may be adjourned, CD may be called, interim may be continue.
Name is there, no?
In this case, only charge sheet submitted. 4040.
Charge sheet it has been submitted as submitted by learned edition. For the scanned copy of here.
At CS number option 170/25 dated 30/12/25. TCR will be confirmed.
May it please, your lordship. Well, I beg to mention item number 36, my lord. It may be passed over only for the day, my lord. Today some personal difficulty. Item 36.
All right.
Only for the day. The day after tomorrow, on a Friday, any day.
Friday.
One number.
36 CDH, no? Oblige, your lord. Interim may continue, my lord.
Please, your lordship, I beg to mention item 5. The matter may be adjourned for the day, my lord.
5.
भी है तो हम सब चलेगा मौसम में तो वही डाउन माउंट एक Item number 1.
The dispute between husband and wife, my lord, and already 38 days behind the bar, my lord. FIR at page number 8, ma'am.
Page?
Page number 8, my lord, typed copy. No allegation of any demand of dowry. My lord, regarding the injury, my lord, she herself has lost the FIR, my lord, instead of medical attention, my lord, she has lost the FIR by herself. 38 days behind the bar. Kept a knife. I think that's it. Apart from that, my lord, 47 notice has not been given in my language, my lord. It is in English language, my lord. For the letters of Mihir, it is my lord. In the local language. My lord. Confess, no? Ground of correction.
This point number 6 of forwarding report, page 16.
Copy pasted, my lord.
Did he stab the informant or a buffalo?
Regarding point
The
six,
calf of the injured buffalo.
in forwarding, it was treated as buffalo. A bit of by copy paste. Only thing injury part was there by knife. Only thing is there. Injury part was there also. Only thing.
Learned counsel for the petitioner, so hard learned. PP. There is an application under so and so. The informant, who is the wife of the petitioner, lodged an FIR that he was being tortured arrest by the petitioner since their marriage in the year 2020 and on 2012-20 the petitioner went to the place where the informant was living separately and stabbed her in the waist with a knife. Previous injury. Has been behind bars since 2025 and the forwarding report does not indicate the nature of the injury. It appears that the informant herself had lodged the FIR. Which prima facie indicates that the injury may not have been of a grievous nature. Having regard to the above, as well as the period of about 38 days spent by the petitioner behind bars, prayer for bail is allowed. The petitioner shall be released on bail of rupees 50,000 with 2 securities of like amount. Satisfaction of the learned Laka magistrate. And with the aforesaid case, it is further provided that the petitioner shall not try to contact or influence the victim or any other witness. Will cooperate with the investigation. And allowed accordingly.
All right.
Lordship, I request for passover for time being. Your Lordship, this is the third time of the petition, Your Lordship, and the accused persons are arrested on 30 of July. More than 7 months, Your Lordship. And Your Lordship, commercial quantity, kindly may TCR along with case diary may be called from the trial court.
As it submitted,
Has it submitted, Lordship? Now trial is done.
scan copy of here along with CD.
Lordship, TCR along with case diary may be called.
Yes, yes, that's what I've said.
Date 9 may be fixed. February.
Take it.
9 February. Job loss.
Pleasure, Lordship. My lord, it is a trial case, my lord. Trial is ongoing, my lord. Charge-sheeted case, my lord. My lord, in Lordship, kindly see, petitioner has been arrested on 22/8/2025. Today, as on today, my lord, 171 days, my lord. My lord, in Lordship, kindly see the FIR first, page 11, my lord. As many as, my lord, 6 accused petitioners are there, my lord. Petitioner before your Lordship, accused petitioner number 2, Basiruzzaman Lashkar, my lord. All other accused persons are released on bail by your Lordship. I have annexed the order sheet, my lord. Annex are 7 and 8, my lord. My lord, since my lord, I will, my lord, face the trial consequence, I will face, my lord. Here, my lord, your Lordship kindly consider, my lord. 171 days is behind bar. And my lord, all other accused, my lord. Annex are 7 and 8, my lord. Your Lordship has passed the order. At this stage, my lord, I may be, my lord, allowed to go on bail, my lord. I will face the trial, my lord, and the local person, my lord, any on condition, my lord. My simple prayer before your lordship, my lord.
Where is the order?
My lord, order, my lord, page 50. Page, my lord, annexer 744, my lord, your lordship's order. And another, my lord, 49. Two orders I have annexed, my lord.
The petitioner and the wife of the deceased have a relationship, illicit relationship with her also.
My lord,
Conspiracy was done.
my lord,
Right.
absolutely, my lord, their, my lord, allegation, my lord, the deceased was killed by administering poison. My lord, FSL report, Viscera report, my lord, says, my lord, no, there is no nexus as regard the poison, my lord. I have also annexed the, my lord, FSL reports, postmortem report, certified copy, my lord. My lord, from the Viscera report, my lord, it is especially clear that he is on sudden death, my lord. Heart attack, my lord. No poison, my lord. Lord, FSL report page 28, my lord. No poison was detected in the exhibit number so and so, so and so, my lord. Their whole allegation, my lord, the deceased was killed by administering poison. There is nothing in the, my lord, report, my lord. Page 28, my lord. Last line, my lord.
Page 28. Yes. Yes, that is why we granted bail to the one of the main accused.
Already granted, my lord. But I will face the trial, my lord. At this stage, my lord, I will consider, my lord.
All right. Page 45, okay, my order. For first two lines. Charges have been framed by now.
Yes, my lord. Trial is going on, my lord. Last date, my lord, was, my lord,
The fourth page, and charges have already been framed. Is the trial is ongoing. There are 5. Then para 6. Additional PP subset. Here the CD was called for in connection with another bail application of a co-accused, which revealed sufficient material against the petition as reflected in the dated 6/8/1/26. passed by this court in bail application number 3912 of 25. Paragraph 7. Wife of deceased was accused number.
Accused number 1, my lord. He has been released on bail, my lord. I have annexed the order, my lord. Is Rina Begum Barbuya.
After 7, you write, in the meantime, all accused have been granted bail.
All the
including
accused have been enlarged on bail, all accused, my lord, except the present
including
petitioner. my lord.
the main accused, that is accused number by the aforesaid order dated 8/1. Six. By 8, para 9. Wait, how many days?
My lord, today is, my lord, 171 days, my lord. He has been arrested on 22/8/2025.
Rest will be 11, 12.
With your lordship indulgence, my lord, session case number 355 may be mentioned, my lord.
Connection with sessions.
Sessions case number 355/2025. Pending in, my lord, session
Pending
and
before?
special judge Kasar, Silchar Kasar.
Achha. Yes.
Obliged, my lord. Highly obliged.
My lord, this matter may be taken up along with item number 20 and 45, my lord.
45 is against this petitioner again. It's the same PS.
Infrastructure. Item 45 has begun infrastructure because the petitioner has been
That is
arrested.
still pending against this petitioner and the CPS, same PS case. AB.
Item 45 is infractious.
Because he has
Arrested.
arrested, my lord. And this present petition, item 55 has been filed, my lord.
CDS come.
Yes, come.
Take up with that. Same council is there.
My lord, I am.
Then we can take it right now.
45. 45 has become infractuous because he has already been arrested.
Item 45, you write this matter has become infructuous in view of the arrest of the petitioner. Says infructuous.
No, this has.
20, my lord, the petitioner is arrested on 23/12/2025, my lord. Today is the, my lord, 39 days. Item 20, my lord.
This is the FIR.
Lordship will find page 18. My lord, the forwarding report, lordship will find at page 21, my lord.
Yes, what is this CD?
Find out one person got grievous injury. And my lord, eyewitnesses statements are there, my lord. In fact, in your witnesses statement is also there, my lord. That they have assaulted. Some altercation took place, my lord. A woman, lady member of the family, my lord. Regarding urinating in the premises, my lord. Then altercation led to this assault, my lord. But the injury is grievous, as per the injury report.
But so far injury part is concerned, my lord, that was not by the attack of the, my lord, by the either by the petitioners or by the family members of the petitioners. Because the, my lord, the picnic spot is, my lord, Hatisila, my lord. This is, my lord, the bank of the river Brahmaputra. My lord, there is a my lord, stone is there, my lord. So while running from the paddy field of the petitioners, my lord, and they were in drunken state of, my lord, mind, my lord, and they, my lord, there is possibility that they may fail in the hole of the, my lord, stone, my lord. So there is,
Both legs broken by falling.
my lord, there is
So
possibility,
there are
my lord.
independent witnesses version are here, and they have stated and specifically named them, my lord.
But, my lord, they have unauthorizedly entered into the paddy field of the petitioners, my lord.
What is the stage of the investigation now?
The injury report collected, my lord. Then the last update is of 22/12/25, my lord. And that as per the last update, my lord, this petitioner of item number 50, my lord, this 55. On that day, my lord, he was arrested. My lord. As per the last update. Otherwise, their involvement is there, my lord.
Date of arrest is different in respect of.
Yes, my lord.
In respect of
Item
Five is how many days?
My lord, item 20, my lord, today is 39 days, my lord.
55?
55 is, my lord, only on, my lord, today's 7 days, my lord. On arrested on 21/01. Because, my lord, they have unauthorizedly entered into the paddy field because petitioners never went to the, my lord, picnic spots, my lord. If only the female members are there, they have, my lord, used slang languages, my lord, and also urinated in front of the, my lord, female members, my lord. There is no, my lord, physical attack on the, my lord, either informant or his associates, my lord. But may impose any conditions, my lord. Because the, my lord, the family members of the petitioner also lost their affair. But, my lord, that has not been registered, my lord. Subsequently, they have lost their complaint before the commissioner of police also. Narrating the, my lord, true and correct facts, my lord.
Both leg fractured, my lord.
See the CD. Mark the statements in the report.
Statement as I have marked me.
Yes.
One report is awaited.
Report, there are no any cases registered against the petitioner.
The additional PP on instructions received submits that case has been registered against the present petitioner at which PS?
Barbara PS.
Hence, matter is closed accordingly.
Actually, the FIR is on page number 8. There is the page number 12 is the vernacular one.
Of the case there, since it was rejected earlier.
Yes, Lordship, one thing is that it is rejected by the Clarendon Court of Session. Lordship, I may be allowed to peruse the very small FIR. Perhaps page number 12, Lordship. সম্মানপূৰ্বক বিনীত নিবেদন হৈছে আজিৰ পৰা 1 বছৰ 6 মাহ মান আগতে এদিন মই বেংকৰ কামৰ বাবে মাটিয়া ইউকো বেংক অভিমুখে গৈ আছিলোঁ সেই সময়ত 1 নং পদকীয় মোক মটৰচাইকেলৰ আগুৱাই দিয়াৰ প্ৰস্তাৱ দিয়া মই সৰল বিশ্বাসত 1 নং পদকীয়াৰ মটৰচাইকেলত উঠো 1 নং পদকীয়া মোক মাটিয়া ইউকো বেংকলৈ লৈ যোৱাৰ পৰিৱৰ্তে মোক জোৰপূৰ্বকভাৱে দুধনৈ লৈ যায় আৰু মোৰ শালীনতা হানি কৰাৰ লগতে বেয়া ইংগিত দিয়ে One thing is that this is the statement that it shows that both the persons were known to each other. So certain criminal intention is not there. And second part is that the outrage of Nodacity Alice, which stated to have happened in the broad
The
daylight.
allegation is of rape and as you have stated, it was rejected after finding material against you. So you have to see the CD. Yes. See.
11-2.
It's an anti-safety bail application and also the FIR is at page 40. Yeah, you can also. I'd like to inform you that the iron cattle traps at VIP Road near Potixa Hospital were recently replaced with concrete slabs, and the removed cattle traps were kept in the roadside for further disposal as per official procedure. However, last night these iron cattle traps, 8 numbers in total, were found missing and were suspected to have been stolen. Today, during strict vigilance on this matter, one of our section assistants, while inspecting the site in the morning, found out one JCB bearing register number so-and-so, one dumper truck bearing register number so-and-so, loading the cattle traps into the truck. Upon confronting them, our section assistant was overpowered and the individuals managed to flee from
Okay, same thing earlier rejected.
Yes, Your Lordship, yesterday. By the session school. May I pay for a short deal if Your Lordship kindly?
Alright.
Obliged. Charge sheet already filed and someone issued, so in the charge sheet he was shown absconder minor. But kindly see the FIR page 11. After 9 months, this FIR was lost, and you lost against the ground which was given, page 11. Paragraph 6, 7. Husband came to know immediately matter, that's why paragraph 6 matter. Thereof charge sheet was filed. Actually, my enmity with the husband in paragraph 4, I have stated details minor. After 9 months, and your loss he was shown absconder, page 19. And the 2 person mentioned in the FIR, my lord, about the wife of 2 colleagues, they are even not cited as witness also, my lord, in that conduct. Then the charge sheet, my lord. Then he was transferred from that place, my lord. Your lordship will find cognizance was taken page, your lordship will see page 22. Page 22. That is 3/10/23. And he was transferred, my lord, in June 23. My only case, my lord, I will appear, my lord, I may be given opportunity, my lord, I will appear because now he is not here, but he assures that he will attend all the dates, my lord, whenever he is there, my lord, he will never be served, my lord. This is the short prayer at this stage, my lord, because since charge sheet file someone issued. Now next date here, lordship will find last.
You appear and apply for bail there.
Your lordship also may can't, my lord. I will appear, my lord. I will appear. Next date is on 33-0, my lord. When I was not there, I have given my paper also at that moment. Anyway, I am not married at this stage, my lord. I will appear. Date is fixed on my lord 30. 30, my lord. 30. Your lordship will find page 38. Page 38. They have issued notice several times, but because of my transfer from this place to that place, mother, it could not be served. Ultimately, it was served, my lord, and I took step from my advocate, and subsequently, my lord, only 2-3 days I defaulted mine. I did not come, my because of the transfer, and I have never received notice earlier. Now, page 38 on the next date is 31/26 for appearance, and I will appear, my lord. My mail will be granted. I am only one that I will not never default, my lord, in appearing in the trial, man.
It's a case of 22. That's asking.
But we filed the FIR after 9. And
File some criminal petition
they have
also.
never searched, my lord, never arrested. I was in the office, my.
It is mentioned that you filed some criminal petition before the High Court.
Well, that was quashing petition, my.
What happened there?
Quashing was not, my lord, that was not allowed. I have stated, my. In my paper. That was a quashing. Now I have come because this day I received the notice, summons, my lord. Now I issue summons.
Records may be called for this because records and lordship will consider the paper.
And your lordship find this whole one interesting cases, my lord, on merit if I came, my lord, if I come, your lordship will find he has annexed the certificate that he was on leave on that day because
Okay, let us call for TCR then. If you are on merit also.
no, I am, my lord,
Otherwise you appear, they will consider.
my lord, they will consider I will appear, my lord, my only once I an employee, my lord.
Without seeing anything, how can we grant you a
Government
blanket
employee, my
protection?
lord. And also, my lord, the similar order of the sovereign court, though your lordship was not bound by the single bench. But it is also that I have, my lord, submitted.
But
Here, the number your lordship kindly see. Last, my lord.
Page 43, 44, your lordship.
44, 45.
44, 45. Similar case, my lord, similar, well, though your lordship not bound, but similar, my lord. Page 44, your lord, signed the paragraph 5, my lord. The Lord Counsel for the accused applicant submit that since the accused applicant has not been arrested by the police till date, he was all along in the office, my lord, never searched even. And as the charge sheet has already been filed, he should be allowed to appear before the interim protection. Thereafter, this bail was given, my. Last page, your lordship will find page 20, 45. Paragraph 8, my. The investigation of complete government servant, no question of my absconding now here, because he did not receive earlier notice. This is the because of that, man. And it could not be served also. Because of change of address, man. Forward there.
The case of 24 and charge sheet submitted on 26,
But I have
25.
not received notice. It is on the record, my lord. Your lordship will find.
It appears you have avoided appearing for a long time. Every time you file a petition this way, that way.
No, I received the notice only on 24 last, my lord. 25 only I received notice. Only 25. Your lordship will see. 10 from page 33 it starts, my lord. That report he has not returned with any report issue afresh. Then, my lord, you are page 34. On perusal of the case, it is seen that by a report was received. On perusal of the report, it is seen that the same incorporates the transferred address of the accused. This is 6/6/25. And as such, let fresh summons be issued. Then fresh summons again issued, my lord, on your page 36 that I have just shown, my lord. Learned counsel appear on behalf of the accused person has filed petition bearing so and so stating that he is currently under. First time I came to know, my lord, 25 and I appeared with staff, my lord. Trade for allowing him to another date to mark. Hard, peruse the petition, consider the ground mentioned, same is allowed the direction, stick direction, 1/9/25. In that next date, my lord, he could not come because he could not get leave, my lord. This is there in the order itself, my. 1/9/25. First he received in, my lord, in the mid-September of 25.
June 25.
June 25. Only first after 4 years, my. Because of transfer to Agra, and your lordship will find he had not got leave also, my lord. Page 37. The army man, my lord, they will never default, my lord. He will, whatever may be there. Once he came to know, he immediately came, he engaged advocate and who took time, man. It's not that he was all along, my lord, 4 years he remained outside. It is not that, man. In page 40 also, my lord, on merit, on that day, my lord, he was in other place, my lord. You see? You heard me.
8.
So I have a case on merit, but I am now at this stage, but only for that purpose, man. Nobody will be prejudiced, my lord, he appears in the gates on bail, my lord, because he will go on appearing. Your lordship makes strict, so if he fails, my lord, certainly bail will be cancelled.
That is the problem that in this
No, my
manner,
lord,
if we grant protection,
army man, my lord.
everybody can avoid and then say charge sheet submitted.
Oh, my lord, only 3 dates, my lord, he. Your lord kindly say what is the, because address was changed, he was transferred from this place to Agra. That's why they could not serve the notice. It's not my fault, my lord. Whenever I got notice, my lord, I immediately engaged advocate, I think. Thereafter, next date, my lord, leave was not granted. He is a central government employee, my lord.
I have Muslim here before your lordship that after investigation, he was not cooperating with the investigation.
No, I did not get notice for petition of cooperation, my lord. You kindly see paragraph 4 and 5 in my petition, my lord. Page 4, my lord.
Last part.
Details I have mentioned, my lord. I was on Jurhat, my lord, during that period. Almost 1 year, never searched, my lord. He was all along on duty.
Page number 4 last.
Page 4, last part, you work on this. This is summons in the month of June 25. Paragraph, page 4, paragraph 3, last my bottom, page 4. Then he comes to appear, my lord.
The next page.
Then paragraph, you might have, petitioner had, you might have paragraph 4. That question I came, my lord, because immediately that question was not allowed because he said that since action file, he
Right.
faced the trial, because plea of LEV was taken, my lord. Then paragraph 4, my lord, that about this enmity with the husband. In the FIR, she said, but immediately after coming husband, she reported. The kept my lord mom, and only after 9 months, FIR was lost, my lord. But employee might only if he gets arrested, certainly might listen. Now he assures that might will appear.
Heard Mr. Chaudhary, learned counsel for the petitioner.
Amjad Qadir.
Petition under so and so. Paragraph 2 of the bail petition. They submitted that during the course of investigation, so the petitioner was very much present.
In his office.
Place of posting at Jorhat. This did not
He was transferred in June
Arrest him.
25,
23.
23.
put any notice to him. Further stated that paragraph 3. It is further submitted that the incident FIR has been lodged 9 months after the alleged incident. Previous grudge of the petition victim and the petitioner. It is further submitted that petitioner is ready to face the trial and there was no fault on his part. Parents, as he neither received any notice. And after receipt of notice, he was prevented by valid reasons from appearing as indicated above. Where during the above, it is provided that the petitioner shall appear before the learned trial court on the next date fixed.
Page 38, man.
In the event of his arrest, he shall be jailed. provided that. For it with the. Regularly appear before the trial and. Yes.
I am the FIR name accused, your lordship. There is two accused person, your lordship. That is, your lordship. Lordship will find it at page number 12, your lordship. Iftikhar Hajorika and Joyson Hajorika, your lordship. Along with 5 others, your lordship. Now, if lordship kindly come to page number 16, your lordship, that is the forwarding, your lordship, of this petitioner, your lordship. Now, if your lordship kindly seek ground of arrest, your lordship. That during investigation, it is reliably learned from credible and trustworthy sources that arrested accused Muhammad Joel Ali knowingly provided shelter and refused to the FIR name accused persons, namely Iftikhar Hajorika, son of Joyson Hajorika and Joytun Hajorika, who were absconding and evading lawful police apprehension in the present case. That it is further revealed from the reliable sources that the arrested accused Muhammad Joel Ali actively assisted the FIR name accused persons in freeing and concealing themselves with the intention of helping them avoid arrest and obstruct the course of justice. During interrogation, the arrested accused person, Joel Ali, admitted that the FIM accused person, Iftikhar Hajorika and Joyson Hajorika, stayed in his house and were harbored by him while they are absconding from the police. That the acts of the arrested accused Muhammad Joel Ali clearly disclose his intentional intervention in the harboring and hiding the accused person, thereby facilitating their evasion from lawful arrest. Now, if lordship, if it is so, your lordship, that this offense will attract 249 of BNS, your lordship. Now, 249, if your lordship kindly see the schedule, your lordship, of BNSS, it is bailable in nature, your lordship. Again, if your lordship kindly see the 48 of the BNS, your lordship, served to the wife of the petitioner, that case number 21, your lordship. Same ground of arrest has been recorded, your lordship. Same thing, your lordship. Because of the petitioner allegation is that petitioner gives shelter to Iftikhar Hajorika and Joytun Hajorika, your lordship. That attracts, your lordship, 249, your lordship. 249 I have recorded in my petition itself, your lordship. And if your lordship kindly see the schedule of the BNSS, your lordship, that is bailable in nature, your lordship.
They have put 109 against him also. Aglandet counsel for the petitioner. Additional PP decision. Then page 14, page 14 brief of the case. Result of the forwarding report in respect of the present petitioner. It appears that the attributed to him is that provided shelter to the main accused persons. Who were absconding and evading arrest. It is submitted by counsel for the petitioner that even if the said allegation is accepted at its face value, it's section 49
Nine, Your Lordship.
BNS be attracted, which is bailable in nature. Having regard to the contents of the forwarding report, I find force in the submission of learned counsel for the petitioner. The date of his arrest, the petitioner has by now spent about 12 days in custody.
Then 15 January, Your Lordship, that's the one. 15.
Considering the above, therefore bail is allowed. So and so shall be released on bail of rupees 50,000 with one security of like amount. That's learned 11 magistrate. Provided that the petitioner shall cooperate with the investigation.
Much obliged, Your Lordship.
Your Lordship. 482 pre-arrest bail application, Your Lordship. The FIR is at page number 14.
Yes.
Your Lordship.
Hmm.
Lordship, all the attributed section except section 132 are bailable, Your Lordship. And the maximum prescribed punishment under section 132, that is assault or use of criminal force to deter public servant, is maximum of 2 years, Your Lordship. This is a purely civil dispute, Your Lordship, and there was an altercation of words between the parties, Your Lordship. And considering the case, Your Lordship may extend pre-arrest bail, your interim pre-arrest bail, Your Lordship.
The police person of this person also sustained injuries, Lordship.
Yes, PP.
Lordship, police personnel also sustained grievous injuries for that.
Previous injuries.
Lordship,
CD with medical.
What is the
report.
section then?
Your Lordship, 1172, voluntary causing grievous hurt, 117 bracket 2, Your Lordship. That is bailable, voluntary causing grievous hurt. 351 to Your Lordship, criminal intimidation, that is bailable, Your Lordship. And 351 to Your Lordship is non-cognizable and bailable, Your Lordship. The FIR has been exaggerated, Your Lordship, and most of the parties are women, Your Lordship. They are commanders of black commandos, Your Lordship.
Learned counsel for the petition. Additional PP. Application under so and so. Paragraph 2 of the bail petition. Call for the is submitted on behalf of the petitioner that the only non-bailable section called is section 132 BNS, which carries a maximum of 2 years imprisonment. In regard to the above, it is provided in the interim that their arrest, the petitioner shall be released on interim bail of rupees 50,000 each with 1 share like amount to the satisfaction of the arresting. Connection with the aforesaid case, it is further provided that the petitioner here before the IO within a period of 7 days with the investigation. CD along with injury report. Okay.
Lordship, 16 February.
Deeply obliged, Your Lordship.
Right, please, Your Lordship. 482 application, my lord, for pre-arrest bail, my lord. The petitioner is a lady, my lord, and you also will find the FIR at page, particularly at page 13, my lord. Three persons are named, my lord. That they opened a self-help group, my lord, for depositing money of the villagers, my lord. And now allegation is that they have not returned the monies, my lord. Accordingly, one person has lost his affair, my lord. The petitioner is the, my lord, wife of the second number accused, my lord. She is the wife of second accused, my lord. She has no way connected with this business, my lord. Only because he could not be arrested by police, my lord. The police is trying to arrest her, my lord. Except that nothing, no other allegation is there, my lord. I am his wife because they are after me, my lord. Petitioner number Asadur Rahman, my lord. I am his wife, my lord. I am not named also in the FIR, my lord. And I will fully cooperate with the authority, my lord. And my humble submission that custodial interrogation is not necessary. And this is a matter relating to records, my lord. Everything has been seized, my lord, from the office. And I have 2 minor children also, my lord. I am the wife of the second accused, my lord. And that is the only thing, my lord.
Heard Mr. Learned counsel for the petitioner and learned edition. This is an application under so and so. As per the paragraph 2. It is submitted on behalf of the petitioner that the petitioner is the wife of the accused number
2, my lord.
Of the accused number 2.
2, my lord.
And she is in no way connected with the present case and also not named in the post of CD. provided that entering that in the event of her arrest shall be released on interim bail of rupees 1,000 with one surety of like amount to the satisfaction of the arresting authority in connection with the efforts of this. Operate with the
Will appear.
litigation and appear before the IO within a period of 7 days from today. Placed again on
17th.
Obligement.
May I please, your lordship? The FIR is at page 17, my lord.
yes.
So here, my lord, may I read out? I have the honor to report that I have made an inquiry today on 27/11/25 at around 3 hours. As per source information and as per above GD reference that one Mangaluddin, which is before your lordship, of village so under Borbeta PS along with his son, Nazir Rahman, aged 26 years, has been running an illegal money lending business from long time at exorbitant interest rates. It was also informed that they have a history of mentally and physically torturing the public in connection with such illegal money lending activities. They have been demanding and harassing various people with an interest up to 10% per month, additionally with conspiring to derive monetary benefit from all by cheating. During inquiry, SIUB Ujjwal Pegu along with a WPC and available battalion staff proceeded to the house of the said accused persons at village Khandarpur. A house search was conducted in presence of independent witnesses, namely so and so and so and so of Bandipur, during which the following articles were recovered and seized. Number 157 numbers checkbooks, total 46 numbers blank pages with revenue ticket signature, 2 numbers RC VAT registration number so and so and so and so, and 2 numbers ATM card VAT so ATM number so and so and so and so. Total 43 numbers of illegal money lending, namely Indian non-judicial stamp. During the house search, accused Mangaluddin was found absconding. However, his son Nazir Rahman, aged 26 years, was apprehended on the spot and brought to Borbeta police for further interrogation and necessary legal action. So this is the FIR, my lord, and based on this FIR, case is registered under subsection 2 of section 1113, subsection 5 of section 3 and subsection 4 of 308 of the BNS. Now, my lord, here it is a pure case of money lending. So for that purpose, there is an act called Assam Money Lenders Act of 1934, so which has been amended twice, and as per Assam Moneylenders Amendment Act of 1968, section 12, my lord, 12A was inserted, and 12A, my lord, I am furnishing a copy. The latest amendment of 2022 and the 1968 amendment is given, my lord.
Yes.
So I am on 68 Amendment Act, page number 4, where 12A. Prior to that, 7, it says, after section 12 of the Principal Act, the following shall be inserted as section 12A, namely, 12A, no court other than a court of magistrate of the first class shall take cognizance of or try an offence under this Act. 2, no court shall take cognizance of any offence under this Act except on a complaint in writing made by an aggrieved person or an officer not below the rank of a sub-inspector of police, or by the registrar or any other officer specially or generally authorized on his behalf by the state government. So this is the mode of making a complaint. Now, my lord, as per the Amendment Act of 2022, section 12 was substituted, and it says that for the first offense, rupees 30,000, and for the second and subsequent offense, only 60,000 is prescribed. But here now, police registered the case under the organized crime, section 111. So the definition of organized crime and the economic offense that is given in the explanation to section 111, the present case doesn't fit there, my lord. Because as per the definition given, of economic offense in organized crime, it includes criminal breach of trust, forgery, counterfeiting of currency notes, bank notes, and government stamps, hawala transaction, mass marketing fraud, or running any scheme to defraud people or doing any act in any manner with a view to defraud any bank or financial institution or any other institution. So the Amendment Act of 2022 and the 1968, it only prescribes the mode in which the complaint has to be initiated and the maximum punishment.
Which section?
Section 12 of this Assam Moneylenders Act.
Amended Act does not mention that. Amendment does not mention who is to have lodge the complaint.
No, 68 there. No, the 1968 amendment. It says, page number 4. There are total 5 pages I have given. 1968 is there, my lord. At page number 4. (12A). After section 12A.
So who has lodged the present complaint?
Before the officer in search, Borpeta PS.
Who has lodged? Sub-inspector.
Yes.
So,
But this is the manner. Assam Moneylenders Act, it says so, my lord. So the subtle
this
position of
page 4, this page 4 that you have given,
Yes, my lord.
12A.
12A, A1 and A2.
One is regarding taking cognizance, that's different.
Yes. 2, my lord.
The court shall take cognizance under except on a
Except on a
complaint in
stipulated
writing made by an aggrieved person or an officer not below the rank of sub-inspector of police.
Yes.
So here it is sub-inspector of police.
Yes, but he has not made that complaint to the magistrate.
Yes.
And furthermore, my lord, kindly
That does not.
the
right,
definition
because
of
it is not
economic
listed
offense
under
may be
that
seen.
act.
My lord, kindly the definition of economic offense
Yes.
given in the explanation of section 111 may be seen. And my lord, 2022 amendment, it says only imposition of fine. No imprisonment is there prescribed. 30,000 for the first and for the second and subsequent
PP.
60,000.
Lordship, wait, Lordship, because Lordship, from him, Lordship, 57 number of checks, Lordship, total 46 number of blank checks, Lordship.
Yes, already these are recovered. Police
Lordship.
seized from the position of the son, who is also behind the bar. Not from the position of the petitioner. For a money lending business, my lord, how can 111 comes? No section of this Moneylenders Act is put there.
But Mr. Learned.
P. Boda.
Additional. If there is an application under. For the allegation, the FIRs. Paragraph 2. Learn counsel for the petition that although the case is registered under section 111 within bracket 2 within bracket small b with other sections of the BNS, comma, the said section pertaining to organized crime attracted in the present case. Since the principal allegation against the petitioner is pertains to money lending, which is not covered by the definition of economic offenses provided under section 111 BNS. Further submitted that at best provisions of the Moneylenders Act
1934.
as amended would be attracted, whereby as per section 12, it is provided that whoever acts in contravention of the said act be punishable with a fine of rupees 30,000 for the first offense and rupees 1,000 for the second offense. Said offenses would naturally be bailable. Having perused the relevant provisions cited above, having regard to the aforesaid submissions, for the CD. Meantime, in the event of his arrest, the petitioner so and so is done interim bail of rupees 50,000 with 2 sureties for like amount to the satisfaction. Connection with the aforesaid case. Further provided that the petitioner shall appear before the IO within a period of 7 days. Cooperate with the investigation. Is the matter again on
18th of February.
My lord, one connected matter is fixed on Friday next. 172 BA 172 oblique 2026. 172 of 2026. Highly obliged.
Please, Lordship. Lordship will find the FIR at page 13, the translated copy. Where is Lordship? FIR dated 12/1/2026. With due respect, I beg to state that today at around 6 p.m. on 12/1/2026, when I was reversing my car on my way to Tezpur market from Zenaki Port, I collided with a bike of the following person. When I got out of the car to ask him, the bike rider shouted on me using obscene languages and forcefully touched my private part. Then when my husband and father-in-law came to rescue me, both the bike rider, namely Iftikhar Hazarik and several others, came and beat my husband and on the head with the intention of killing him. Occurrence of which my husband and father-in-law got grievous injuries. After beating them, the bike riders and several persons left the place, and while leaving, they threatened us, saying that the Hindu dominance won't work in this place. Hindu Adhipatya Solivo. I am not in the name in the FIR, Lordship. I was not in the place of occurrence, Lordship. When I when I was informed that bike rider along with in the bike, my daughter aged about 9 years was there, and she got injured, Lordship. Then I immediately went to the took her to the hospital, and well, Lordship, what I
number 2 but 2 detention to the so and so. X of the case same. Same FIR.
I'll appear before the your lordship and
Error.
for my statement.
It would be. Call for the CD. Regard to the fact that the petitioner is not an FIR named accused. Provided that same before the IO within period of 7 days.
Deeply obliged.
List on
16.
Deeply obliged.
May I please your worship? This is an application under section 482 of CRPC, your lordship. FIR, your lordship will get it at page 17. There is a clash between two group of youths, your lordship, belonging to rival political parties, your lordship. And I came in between, your lordship. In page 18, your lordship, some persons are named. I am not there, your lordship, among those. Now, your lordship will kindly see, your lordship, page 21, your lordship. 22 is the original, your lordship. My uncle has lost an FIR, your lordship. In fact, your lordship, in this chaos, your lordship, my car got damaged, your lordship. I was beaten up. I have also lost the 2 photographs, your lordship, where I received injuries, your lordship. I was not named also, your lordship, in the FIR, your lordship. One Asik Ali alias, someone is named. I am the only bread earner for the family, your lordship. Page 23 and 24, your lordship. And your lordship will kindly see page 21, your lordship. This vehicle also, your lordship, I have to leave the place without the vehicle, your lordship. And this was, your lordship, that's seized by the police, and it is with the police in the police station now, your lordship. Now, this is a clash that has taken place, your lordship, between two groups, your lordship. They beat up each other. I was returning from dinner, your lordship, taking at someone's place, your lordship, and in that milieu, your lordship, I got caught up, your lordship. And ultimately now, your lordship, since my vehicle was there, your lordship, police is also after me, your lordship. Your lordship may call for the case there, your lordship. In the meantime, some protection, your lordship. He is the only bread earner for the family, your lordship. Otherwise, your lordship, I know, your lordship, allegations are serious in nature, your lordship. But since I am not being named, your lordship, in spite of that, my vehicle has been seized by the police, your lordship. I pray for your lordship some interim protection, your lordship. If your lordship finds something in the case that your lordship, I will face the music, your lordship, ultimately.
From Dispur PS Lordship, short date movie.
In fact, your lordship, it's
This is registered under which section?
lordship, these are the section page 19, your lordship. 191.1, 191.2, 191.3, 118.1, 324.4. Of this, your lordship, 118.1, your lordship. 109 is your lordship. 10929.
09 is there.
Lordship.
109 is there.
109 is not there, your lordship. 118.
Oh, yes.
191,
One zero nine is there, Your Lordship, page 20, Your Lordship.
I think type copy it's mistake.
Yes, Your Lordship. 109 is there.
But Mr. Learn for the petition and. The allegation as per the pair is left. While the complainant was engaged in preparations for Yuva Divas, he held it for Dev Kalakshetra on 12/1/26. While the complainant was driving his vehicle, he was stopped by several people near 6 Mile and severely assaulted, because of which he injuries. The basis of the aforesaid FIR, the present case has been registered. It is submitted by learned counsel for the petitioner that the petitioner is involved in the case and he is not named in the FIR either. Para call for the CD. Having regard to the fact that the petitioner is not an FIR named accused, it is provided that in the event of his arrest, the petitioner is on interim bail of ₹50,000 with 1 year like amount. Satisfaction of the arresting authority. It is further. Still appear in 7 days before the.
Deeply.
I corrected the investigation based on.
19-2.
Deeply.
Wait, Your Lordship. Well, this is the application under 226, my lord, challenging the proceeding drawn in Kolkata jurisdiction, my lord. What happened in this case, my lord? Arbitration proceeding for recovery of loan is already continuing in Mumbai jurisdiction, but in Kolkata, my lord, they have suddenly filed this criminal case. My lord. Whereas loan has been disbursed in Hailakandi and Koringanj district, and the jurisdiction in Mumbai. But the criminal case the respondent has filed in Kolkata. This kind of case already covered judgment I have also with me, my lord. This court has already passed judgment.
So what to do now at this stage,
My lord,
other than issuing notice?
yes, my lord, notice may be issued, my lord, and in the meantime, my lord, the criminal proceeding may be stayed, my lord. In fact, Supreme Court has also passed in such orders, my lord. This is mentioned in this, I have given the judgment kindly, may be seen, my lord.
And you should have approached Calcutta High Court.
No, my lord, this court has jurisdiction under 226(2), my lord. In the, kindly see, my lord, this judgment I have provided, I have given, my lord. Altaf, that is Abdul Latif, my lord. That is in Shushikant Prasad, my lord, page para number 5, my lord, is clearly mentioned here. In Shushikant Prasad versus MD Kadir, my lord. May I read, my lord? It's only the abuse
Is
of
this case, is this a
similar, my lord, similar.
same transaction? Or different,
Well, similar, my lord. In my
but
case,
not pertaining to the present transaction, different transaction.
one transaction, my lord, but that is also in similar way. Here comes the regarding the jurisdiction, whether this High Court can interfere or not, my lord. For this is given, my lord. And in my case, my lord, kindly see the award I have annexed here, page 18, my lord, of my writ petition. This is the award of arbitration proceeding regarding the recovery of loan. This is continuous process. This is going, and thereafter, my lord, at the last page, I have annexed the proceeding, my lord. They have filed a complaint in Kolkata and someone has been issued. Subsequent order has been passed, my lord. Page 23.
Learned counsel for the petitioner. An application under Constitution of India, praying for pushing of the complaint bearing case number is 16, okay? Judicial magistrate so and so. Is submitted that the dispute between the complainant and the accused stroke present petitioner is regarding business loan. The petitioner from one Minty Fee Finserv Private Limited. Complaint has been lodged by the firm.
Yes, ma'am.
That is the complainant firm. A dispute of a civil nature. And in this regard, an arbitral award dated
That is 14/6/2025.
25. Not an arbitral award, it's an interim order.
Interim order. Yes,
It's ordered
ma'am.
an interim order at 14/6/25 under section 17 of the Arbitration and Conciliation Act has already been passed. By the sole arbitrator adjudicating upon the dispute between the parties. However, the complainant has chosen to refer a complaint case. The Chief Judicial Magistrate at Kolkata which has no jurisdiction over the issue in a the transaction took place at Hailakandi. Yes. Hailakandi in and no part of the cause of action has arisen in Calcutta. What is happening in Bombay? He was mentioned something.
Mumbai is
about-
the, my lord, as per agreement, Mumbai is the original place where suit or arbitration, anything may be filed in Mumbai, as per agreement.
As per the original agreement between the parties, place of suing has been agreed as Mumbai. That reason also the learned courts in Calcutta do not have jurisdiction of where it is. Para 5 of this one. 5. Perusal of the documents next to the writ petition, it prima facie appears that the action has arisen at Hailakandi in Assam. Where issue notice to the respondents to take steps by registered post with learned additional PP on behalf of the state respondent. Extra copy be served upon him. Meantime, further proceedings in case number to Sailabad, Calcutta, case number to Coastal Level. CS number
Case number 15.
CS stroke 156478/25 pending before the Judicial Magistrate, 9th Court, Calcutta. Paid. Order. Please the matter again.
Right.
May it please the laws. It is land grabbing matters, my lord. Again, the judgment of learned additional session judge Kamru, my lord.
Lordship, kindly I'm on behalf of PK Sharma, my senior. We are from respondent R 2 to 8 and 12. My senior is out of station, Your Lordship. That's why he could not attend the. Kindly,
Service is complete in respect of all.
Yes, my lord. Learned session judge failed to take cognizance of the matter, my lord. It is our grievance. He did not even issue notice to the respondents. Now the respondents who are seeking time, they even did not or served notice by the court below. Page 79 of the MP note.
Third learned counsel for the petitioner. All the respondents have been served and scanned copies of the TCR has also been received. Still appearing on behalf of the defense number 2 to 8 and 12. 6. Adjournment due to absence of learned counsel, Mr. PK Sharma representing respondents. Is the matter again on? Yes, give a date.
A short date may kindly be given, my lord, the next week.
The second week of February.
Second?
Seven is Saturday. Saturday. fixed
May,
Saturday.
may it kindly be on the 3rd of February, my lord. On the 3rd of February.
Third. Hearing day. Fourth.
Motion date.
My lord, due to holiday yesterday, my lord, this matter could not be, my lord, payment could not be made, my lord, because bank was closed, my lord. Matter was amicably settled, my lord.
My lord, I have some objection to the submission of my friend. Kindly peruse the last order.
It is okay, my lord. It was probably,
Last order.
I, my lord, wait, my lord, in the meantime, if matter is not resolved, my lord, that there interim prayer may be allowed, my lord. But matter is settled, my lord, due to, my lord, yesterday's, my lord, Independence Day, my lord, Republic Day, my lord, payment was not made, my lord.
Last matter.
The last matter may be taken up.
Last matter was December 11, my lord. My friend is taking plea for the yesterday only, my lord. It was 11/12, the order was there. That if the before the next date it is not settled, then my
Yesterday
petition
it
is
settled, my lord.
my petition, interim petition for interim compensation as per section 148 to be allowed. It is undertaken given by
Yes,
my friend, my lord.
even still undertaking is given due to, my lord, yesterday only, yesterday it was finalized.
Why the yesterday, my lord? It was order 11/12, my lord. 11/12 order, my lord. Why my friend is?
Why not pay today?
Because, my lord, yes, they are paying,
My
my lord,
lord.
today. Process is going on, my lord, for payment, my lord.
My lord, as per instruction, my lord, they did not pay. They are again trying to give a check, my lord. So that they
Therefore,
can,
my lord.
so that they can again, my lord, this
No.
this proceedings
Immediate, my
for
lord,
at
because of
10
what
years, my lord.
He needs, my lord, cash, my lord.
My prayer is that, my lord, as per last order, my IA
What is
is
the amount?
My lord,
6 lakh, my lord.
Only 20%.
How can you pay 6 lakhs in cash?
yes, my lord. Friday, my
lord.
lord, start at first.
My lord, if it is again paid on a check, my
No,
lord,
no, now
then they can again.
now check
Yeah.
is gone. Yesterday it was holiday.
My
there,
lord, as per last order, my lord, if the is not settled,
My lord, Friday
then-
first item, my lord, at 10:30, my lord.
my lord, my interim IA may be allowed, and if any settlement is there, this it comes to 1,20,000, my lord, 20% of 6 lakh, as per section 148. This may be adjusted with the final payment, my lord. If it is paid, this 1,20,000 will be adjusted with the final payment, my lord.
How
That
they
may
are
be allowed, my
settled,
lord.
record will be placed, my lord. Your lordship will consider, my lord. It is there, my lord, how it is compromised. Only I will place my memorandum before your lordship. My lord, Friday at 10:30.
My lord, my objection to the submission, my lord. An order may be passed, my lord.
My lord, already I am submitted. He is entitled to, my lord, interim, my lord. It is a law, my lord. Matter is, my lord.
The last order is clear, my lord. It is an undertaking to this honorable court.
What is the interim you want?
My lord, 20%, my lord, 148, section 148, my lord. He is liable to pay 20% of compensation, my lord, of the
Yes.
compensation amount of the 6 lakhs, my lord. Section 148 of the NI Act, my lord, kindly pay.
Yes, my lord.
No order has been passed.
My lord, in the last occasion, the similar submission was given by my friend, and he has given an undertaking that if on the next date it is not settled, then my petition will be
My lord, it is
allowed.
settled, my lord.
Settled means what? What is the
Settled means
settlement?
payment. He is agreed to pay, my lord.
The whole amount.
The whole amount, my lord. He is agreed to pay.
Yes, sir. Because, my lord, yesterday it was holiday. There was
Today you say by Friday you will pay everything.
Yes, my lord. Friday, my lord, first item, my lord, at 10:30 a.m.
It is submitted by learned counsel for the respondent that due to holiday on 26 January, the payment could not be made. And takes to make the payment by Friday, that is 30th January. Place the matter again on 30/01/25.
Friday, Friday.
Oblige.
Oblige. Well, see, 2 p.m. मतलब we are both agreed, my lord. Any other date, my lord, matter may be fixed, my lord.
Prayer of learned council.
Ninth, my
Both
lord.
sides list the matter again on
Ninth, my lord.
Ninth,
10th.
10th of February.
Deeply obliged, my lord.
Deeply obliged, Your Lordship.
Yes, CD.
My lord, here, in terms of the scissor list at page 27, an amount of 62 lakhs 80,890 has been chased from the house of the petitioner.
Page?
Page 27 is the scissor list. my lord. I am Nikhil Agarwal.
No,
my lord,
what is
this
the matter about otherwise?
my lord, I have sought for Jimma of this cash. And I have an explanation for all this money, my lord, and I'm a businessman and I have given my everything from bank statement to all. So, including the audited balance sheet and everything, my lord. Because no useful purpose will be served by keeping this cash in there. And I can, my lord, nowadays, my lord, your lordship must be probably aware that the Odisha High Court also.
Why was it seized?
My lord, it was seized because it was suspected to be betting amount, my lord, that your lordship will find in the FIR. At page 20. And the FIR type copy is at page 23. Of course, in the FIR, I am not named, my lord. And the basic explanation why I have this money in my home is at paragraph 6 at page 8, and I have given my wife's bank statement, my lord.
About betting or investment fraud, because first para is all about betting in IPL, second para is motivating people to invest with high return.
Yes.
Com-
I'm not a
completely
I have
different.
no involvement in all this. Your lordship will see the money that was seized from my home is at paragraph number 6 at page. Your lordship will first look at paragraph number 4. Shut up.
Where is the impugned order?
Yes, ma'am. Just a moment, madam. At page 97. And although it starts at page 97, the operative portion of the order is at page 113.
The third paragraph, be that as it may. This was the order of 22/1/2025. So more than a year has elapsed after this order also. So I could. Simple man. My dear.
Which part of the order has dealt with this 60 lakhs?
Your lordship will find, just a moment. At page 112. The objection of the investigating officer at page 112.
And 13, be that as it may.
103.
Actually,
109 also.
for it will,
109.
the whole custody of the seized case amount in reference to the petition number 603/2024 starts from page 109.
Where is the money physically now? Has it been deposited into a bank account? Or is it lying in the same manner? The treasury.
In the Markman receipt that I have to check from the record version.
I think I read a line somewhere in the impugned order that it is deposited in the treasury. But by now, what is the status of that money?
My lord, after Sundar Bhai's, my lord, two honorable courts has drafted a formula that how the case amount has to be dealt with. One is before your lordship will kindly look into the Odisha High Court judgment that probably your lordship has dealt with it, how the handling of seized case has to be dealt with. And similarly, my lord, there is another judgment of the Delhi High Court, my lord, also referring to the Sundar Bhai's case. Bangalore, sorry. This is for just for persuasive value, my lord. Because
Is there any, this is the seizure list, but it does not mention any serial number or anything. Is that case required for the purpose of the trial or?
That one report was called for, lordship. Now the case is investigated by also under
Income tax, the enforcement of director of income tax department is handling also lordship the case. So that's a such kind of huge amount. And whereas lordship the was not able to sufficient reason the source of income lordship. But this report is also lordship 20 to 27 to 725. But present status lordship that I am not.
Now ED and income tax department is also in the picture.
What is the present status? What is the present
That
status
is the
their
statement of the
investigation?
IO, but we have not received any notice or no inquiry from those two departments because we have submitted our audited balance sheet to the income tax department. There is no objection of the income tax department in regard to our balance sheet. That's the IO
Objection
statement.
means they are not parties here, are they?
A detailed report is required lordship. What is the present and what is the Department of Income Tax's role in this regard lordship?
This is
Whether
just
they
on
are
the
initiating
dictation of
process
the
or not.
particular SP. A bold statement has been made that is income taxes. So we have given all the documents of the income tax department also.
Because that money has been recovered from this person lordship on the basis of the main mastermind lordship. The basis of his statement that money has been recovered from his home lordship. So
Except the recovery of the money from the home, my lord, if my learned friend can show one allegation that this any witness has said that this money is from the proceeds of crime, we may have to do rethinking on our petition, my lord. Let my learned friend at least show one statement of allegation that this money which was seized from my
It is said in the report that under disclosure by this Vikas Beria, premises of Nikhil Agarwal were
this is the IO statement on the basis of a co-accused, my lord. And I have given the justification before the income tax department as well as I have given the justification that these are money withdrawn from the bank. Part of the money was
We
withdrawn.
are not dealing with a bail application.
Yes, we are seeking custody of the money and we are willing to give an
Statement of co-accused, but that what does it matter? It is not a bail application.
Madam, so far the jimma of the money, what we can guarantee is that we can give an undertaking. If the money, this physical money is not required as an evidence. If in tomorrow in the trial, say after 10 years, if there's a judgment that this money was proceeds of crime, then it can be recovered from us. We can give an undertaking. But keeping the money in the Malkana or keeping it in the custody of the police doing investigation, what will be? So it's not that only the prosecution is this money is required for the purpose of investigation of this case. We can give guarantee for that money.
can give lordship can give one direction to the department again lordship so that lordship one report they may submit that a detailed report lordship regarding the involvement regarding the clarification from the income tax department also because lordship when they here in this report lordship it is also mentioned that lordship department has income tax department has taken up the matter and if it is required for their investigation also or if they are investigating it, then also lordship, then it may hamper the investigation. So lordship, at this stage, lordship, we may call for a report. Lordship may call for a report from the because this report is very old one, lordship, because from it was his report was sent, lordship.
And
now
your
what is present?
and your lordship will see the predicament. The part of the money I have given my wife's bank statement was for the treatment of the father. The father expired in the money, part of the amount. The other part I have a cash loan with the bank of around 50 lakhs. That to interest is daily accruing.
All these statements have been verified by income tax also because this statement has been.
And
also
if there was some material in this case, charge sheet would have been filed. It is a case of 2025. This report is of July and 24. 25, this report of July. Now we are in the month of February, January and in 2026, madam. So investigation also, there is no update in the why date it should not be given to us.
Report is old, but what about the CD? What is it updated?
Because this court has called the CD on number of occasions, only on the last date when your
CD is also updated. Lordship, CD is last entry date is 25/25. Lordship.
my lord, see the predicament of this person.
an opportunity to give a detailed report or say regarding the entire.
That means we are also not in a position to say what is what now.
I can also collect a report from the income tax department.
And these persons are not night operators, my lord. If Annexure 1 will say that we are the owner of an industrial unit at Tinsukia, my lord. It's not that overnight we can dispose of our industrial unit and fled for the 62 lakhs from this country, my lord. We can ensure the investigating authority that if in the trial we are convicted or if there is any order, adverse orders, that can always be taken care of by this court. And this whole cash amount was shown in the audited balance sheet. Simply making a bold statement that the
Even in order to pass an order to hand it over, we have to know what is the state of the money now.
That my learned friend, we have no access.
For a report then.
Only on the last occasion when your lordship was strict to them that they should produce the case diary, otherwise the order sheet
They have
reflects.
produced it, but
But your lordship will see the number of occasions when they have been delaying this matter before this honorable court. How many times this honorable court has asked for the case diary and they did not comply with the orders of the court.
Has been produced, but the last date of entry therein is last date of entry in the CD.
25 Tony.
5, 25, 25.
25?
Since then, the CD has not been updated. Even the report dated by the OC Tinsukia PS of 22/07/2025. The fate of the seized currency or present status thereof is not to for this court to pass an effective accordingly. Tinsukia PS is directed to press report specifically with regard to the status or location of the seized current cash amount of rupees 62,80890 that was seized from the possession of Akhil Agarwal.
From the residence, madam, not from the physical possession.
Residence means your possession.
Yeah, other family members also. My wife money is also there.
The reports are also contain the status of the inquiry made by the said to have been made by the Income Tax Department and Enforcement Directorate. If any such inquiry has been initiated. And updated CD also. Further send back the CD to be resubmitted in updated form. Is the matter again on
11th of February. We are blessed.
Item number 17.
May I please, my lord? Let FIR on page 17, my lord. Here is allegation that, my lord, the wife of the petitioner number 1, my lord, and my lord, informant, my lord, who is the mother of the deceased, my lord. And accordingly, she lost this FIR, my lord, that she has a suspect that the accused petitioners, my lord, murdered her, my lord. That is the basically allegation, my lord. When that, my lord, after the incident, my lord, which was took place on the 14th, my lord, immediate to coming to know that the, my lord, the petitioner number 1 took her to the hospital, my lord. She was treated in the initial.
Yes, PM report.
Report, my lord, received but not complete, my lord.
My lord, I am behind the 67 days, my lord.
So as the PM report. No other injuries are there, so.
My lord, only one thing, my lord, as per my information, my lord, there is quotation of blood coating in the heart, my lord. That is the, otherwise there is no injury mark, my lord.
Black?
Coated blood found in the heart, my lord.
What does that mean?
Might be heart attack, my lord. Sometimes heart attack this happen, my lord.
Yes, my lord, there are reports. Brother of the accused himself, my lord, they fight almost regularly.
My lord, marriage was almost 10 years, my lord. I have a son of the 8 years, my lord. And my lord, she only suspect that I have a relationship with her sister, my lord. Though that is not correct, my lord. On the last date, my lord, that is on the date of 13th, my lord, before the day of the incident, my lord. On the date of 13th, there is the birthday of my child, my lord, son, my lord, minor son, my lord. They also come in my home, my lord. She found something suspicious, my lord. Might be, my lord, that is the main reason, my lord, she commit these things, my lord.
My learned friend himself is, my lord, pointing out. Learned friend himself is pointing out the reason for the offense, my lord.
I mean, that is
FIR mentions about hanging rope and all, but
Yes,
PM report finds no mark
Doesn't say,
there.
my lord.
I am 67 days behind the bar, my lord. I have a small child, my lord, of 8 years, my lord. Presently, my lord, due to my lord lordship's interim order, my lord, my mother look after the present petitioner number 2, my lord, looking after my lord, my child, my lord. Behind the 67 days, my lord. My father custodial detention may not be required, my lord, in this case, my lord.
What does this IO say about the, you go to collect?
Yeah, otherwise, fix it on next week, my lord.
Available by now, I think.
My lord, petitioner took himself to the hospital, my lord. And after then only my informant come to the hospital, my lord. All expenses are bear by the petitioner, my lord. Even in the Nalbari hospital, then Guwahati, my lord, then GMC, my lord.
As you know, otherwise what would have happened? There would have been in the FIR that he did not even take her to hospital. He didn't.
No, my lord, that is, their FIR itself, my lord, says I informed them that I am taking her to the hospital, my lord. FIR itself it says, my lord. I am the person who took her to the hospital, my lord. Immediately, my lord. On the date of the occurrence, my lord, we are not in the house, my lord. We are attended Shraddha in the nearby neighbor, my lord. When we returned to the house, my lord, then we found the situation, my lord. And every household, my lord, some disputes are there, my lord, but there is nothing to the my lord. If my lord, only that, my lord, some persons are who alleging that, my lord, from the family members of the victim, my lord. For
It is not even from FSL, Department of Pathology, same.
That's why madam, I'm praying for short date madam, next week. If
The IO has submitted the case diary, but the post-mortem report contained therein is still inconclusive due to receipt of report from the Department of Pathology, GMCH. IO is directed to learned place for a short date in order to submit the final post-mortem report. Accordingly, list the matter again on
My lord, first week of February, my lord. My lord, till then, my lord, interim order first in respect of the petitioner number 2, my lord, continue, my lord.
otherwise she appeared madam, and record. The CD may be returned madam.
same order passed in respect of petition number 2. Stands extended till disposal of the present bill petition. Send back the CD for resubmission on the next date fixed.
Obliged, my lord.
Wait, please, my lord. My lord, the connected BA number 72 of 2026, which is reflected in the order dated 21/2026, is fixed tomorrow before your lordship. My lord, may this application be taken up as well tomorrow? Your lordship.
Is the matter along with A 72 of 26 on tomorrow.
Direction may be given to the registry because earlier occasion the matter did not came up on 21st. That's why
Registry to ensure accordingly.
deeply obliged.
Please, your lordship. So this case was fixed on 30th. It has come today in the CIS. It is still shown as 30th, and scan copies were called for. There's a possibility, my lord, that if it is fixed on 30th, scan copies may come up.
Is the matter on 30/01 so and so as prayed for by learned counsel.
Deeply obliged.
Here, last occasion, scan copy was called for, not received. My lord.
Scan copy not received, list again on.
Date. Okay.
Yes, next.
Praise your lordship. Here I am on interim bail. The updated scan copy was called for. It has not been received yet.
Scan copy or CD? CD.
Scan copy.
Not received, my lord.
If it's scan copy not received, list again.
My lord, CD was called. for.
CD.
CD.
Use CD as has not been received. Again, on so and so interim order to remain in force till then.
Obliged.
Take it, your lord.
No, perhaps not is not available.
It is not received, my lord.
It is not same order.
Interim order is there, man.
Keep level.
Is your lordship? As per information by the KPB, CS.
Yes, submitted.
What do you want to do? Scan copy.
CS submitted as per.
Yes, what do you want now?
Scan copy lagi.
Will appear.
Will appear.
Learned counsel for the petitioner. Additional PP submits that CS has been submitted by so and so.
Being CS number 201/25. Dated 26/11.
Submitted that. Shall appear before the learned. Accordingly, the present application is disposed of by directing the petitioner to appear before the learned trial court. And in the event of any application for bail being filed, the same shall be considered as per law. Till then, the interim order passed earlier shall remain in force in a period of 15 days.
Obliged.
Ragjyoti Pathak. So we have filed, may I please your lordship, we have filed our rejoinder, parawise reply on transfer to the CBI from the state police. Now, if they feel so that they need to file rejoinder, then it is up to them. However, my predicament is that it was in the state police and the anticipatory bail is filed on the basis on the FIR of state police. Now, on transfer of the CBI to CBI, another case is registered. So
You will have to amend, I think.
your lordship.
You will have to amend it, my lord. It is for them to.
It is informed by learned retainer counsel CBI that after transfer of the case to CBI, a fresh case has been registered. Accordingly, learned counsel, the petitioner requires time to file petition for amendment.
Now the details may be furnished to us, my lord. The details of the case.
Details of the case.
Details of the case.
The details of the case be furnished to learned counsel for the petitioner by learned.
So,
Yes, we have served your
It is
lordship.
okay.
Because
It is
without
contained there.
that,
It is contained there. Details are there.
we have given the parawise reply of the petition, earlier petition.
Set of that you write, CBI has filed
It is their petition.
section and details of the
We have not.
CBI case are contained there.
Okay.
List the matter again on.
My lord, there was an order for interim bail, my lord.
Interim order passed earlier to continue till next date of listing.
That won't be maintainable because now fresh FIR has come.
Since it is a
Automatically, protection cannot be granted, your lordship.
It is a continuation, my lord.
It is arising out of the
Same-
same
same
allegation,
case, my
is
lord.
it not?
Certain provisions, I have seen automatically protection cannot be granted.
It is there, the order is already there on.
Now it is up to the Lordship, then, as your Lordship please.
Go and arrest
15
as you
February.
like. We have passed the order.
In February.
If you think it's not maintainable, go and arrest them.
It's a humble submission before your Lordship, not just, it's a because of the academic thing, that is why.
We are talking about the liberty of an individual, I mean, there's nothing academic to it, man.
Our situation is quite peculiar, that is why
The have the liberty to fight the journalist.
That CD not received, Lordship.
It did not received.
Lordship
Based
received.
again on interim order pass. Any
Lordship,
interim order is there?
1 and 2.
Interim order passed in favor of petitioners number 1 and 2 to continue the next date of listing.
It's been more than 2 months' time, Your Lordship. CD has not been received. A short date may be given.
Give a short date. Ensure.
Yes, sir. Fine.
May it please your Lordship, man. Yes.
Is there, na?
Yeah,
Is there?
yes, that is.
My lord, the first FIR, your lordship will look into the first FIR at page 22, my lord. It starts 22. 22, my lord. This is lordship will kindly see at 1, serial number 1 on the top. It is CBI. FIR number is RC 2172025A 0012. Dated is 3/5/2025. Lordship got it on the right hand
yes.
side top. And if your lordship looks into it, section is 61(2) PC Act and BNS and PC Act 7, 9, 10 and 12. Please look into the 5, serial number 5, down below, place of occurrence, Noida and Dibrugarh. Now, my lord will kindly see at page 27 is the source information, 27. At paragraph 2, my lord. Source information further revealed that on 16/4/2025, Sri Priyat Chakraborty again demanded 17 grams of gold ornaments for himself as well as for some other unknown public servant from Sri Jyoti Kumar Singh against award of certain contract in favor of him. And Sri Jyoti Kumar Singh also agreed to the demand. Source information also revealed on 18/4/2025, Sri Jyoti Kumar Singh conveyed to Sri Priyat Chakraborty that he had taken the approval of the managing director Sri Kunal Gupta for a bribe amount of 7 lakhs. Sri Priyat Chakraborty reminded him that he has not asked for cash and once again demand delivery of 70 grams of gold coin instead. Jyoti Kumar Singh told him that due to some reason he won't be able to purchase gold and therefore he would deliver rupees 7 lakh in cash. Source info exists on 3/5/2000 evening. Jyoti Kumar would be delivering certain cash amount as bribe instead of gold to see so and so near so and so, which is also close to resident of so and so. 5 is the above mentioned act of public servant private person discloses the commission of cognizable offense under section so and so so and so. Sri Priyat Chakraborty is accused number 1, my lord, and so and so. So there are 4 accused, and number 5 is unknown, my lord. Now we approach, our name was not been reflected in the FIR. We came before this honorable court because there was a raid which is been made by the CBI in the official as well as residential complex of the petitioner, who is not named in the FIR. And during the course of search and seizure, my lord, they recovered one file, which file is reflected at page 33, my lord. Your lordship will kindly see the file at page 33. Page 33. This is the official office of the petitioner, C1, my lord.
Yes.
File GM tender number so and so dated 7/6/2024. This is the file which is recovered by them. Now, I approach this honorable court because on the basis of search and seizure, I approach this honorable court. And at page 38, an interim bail was granted by this honorable court. Lordship will see there are certain conditions which was granted at paragraph 15.
Yes.
At page 41. Now, this was complied. Now, in the meantime, at page 42, section 94 was served to produce documents and which has been done by which is your lordship will see at page 44. All this has been complied. Now, at page 46, an affidavit was filed by the CBI. A counter affidavit was filed by CBI at page 46. After the interim bill was granted, there was a affidavit, counter affidavit filed by CBI, and at page 48, kindly be looked into it, my lord. 46 is the counter affidavit filed by CBI. Now, kindly see 48 paragraph 7, which is most important, which is connected with the second FIR, which I have approached this by way of this present AB. 7. The interrogation of accused Priya Chakraborty further revealed that he had received 2 gold chains from petitioner Tushar Kashera, who is before this honorable court, proprietor of Messrs Industrial Trade Agency at Tinsukia, on 12/4/2025 as illegal gratification favoring the said firm in awarding a tender worth ₹3 crores for supply of genset. He admitted to have processed the contract which was awarded during March 2025. The said 2 gold chains have also been recovered and seized. So this is the contents of the CBI when there was a raid which was done by the CBI. Now, Lordship will kindly see, we appeared in pursuance to the direction that has been passed by this Honorable Court as 55. We went to Delhi. My statement was recorded at page 55. Now, at page 57, Lordship will kindly see dated 26/8/2025. The matter was heard, and at page 58, see at paragraph 3, my lord, it is submitted by so and so learned sending of CBI. Charge sheet has already been submitted in this case, wherein the present petitioner has not been accused, thereby indicating that no sufficient material has been found during the investigation against the present petitioner. And their argument in paragraph 5, CBI made a submission regarding maintainability of the instant application before this court. The same again, they are saying maintainability point they have taken up. Now, kindly see paragraph. Accordingly, interim bill so and so year made absolute subject to the following condition. So your lordship made, this honorable court made the interim order absolute by their affidavit which was exchanged, and ultimately found that this can be made absolute. Now, thereafter, a second FIR was lodged by them at page 60. Page 60, kindly be looked into it. Kindly see serial number 1 at page 60. If your lordship looks into serial number 1, they now, earlier it was 12, your lordship please note it, it is now 19. On the first, on serial number 1, 19, and dated 18/8/2025, which was earlier was 3/5/2025. Now please look into 5, place of occurrence, Tinsukia. Instead of Noida and Dibrugarh, now they changed in Tinsukia, Assam and other places. Now, please see, my lord, the 61 at para 60, serial number 6. This is the same IO where they investigate RC12. This is earlier 3/5/2025 at serial number 6, the same IO. Now, this time at serial number 7, now see Tushar Kashera is being accused. And for what purpose? The subject matter being the same, he is offered a genset which was recovered from his official residence, the file. And Priya Chakraborty, the DGM, was arrested in the first FIR at his residence in Noida. Well, while They were raided by CBI. He was arrested. 2 gold chains were recovered. Worth rupees about 2.8 crores. And they recovered and seized. This was a stand which was taken to counter effort by the CBI also. That is the same subject matter of this present FIR at page 63. Kindly see my.
I think we'll have to continue.
Yes, I'm sorry. Yes. At the time of this recession, your lordship was, I was pointing out the FIR at say 63, my lord. First 2 paragraphs, I will not waste the court's time. The first 2 paragraphs.
You
is
can
saying-
go through quickly because we have
just-
already done
my
that.
lord,
We have been there once.
I'll just close it. I'll just put in this way, my lord. If you read the second, my lord, FIR, the contents is the same of the first FIR. And my lord, my submission will be what is there, but is only have to see whether I cooperate with the investing agency. I cooperate 1. Number 2, subject matter of the 2 gold chains which were recovered and seized by Priya Chakravarti and a file were recovered. That is the same replica of paragraph 3. And number 1, number 2, in the first FIR, the place of jurisdiction was Noida and Dibrugarh. And the second FIR, first FIR doesn't contain my name. Second FIR, what they say that your name appears. And third is that place of jurisdiction has changed. But the subject matter is same. Today, what is there, my lord? I have been protected by this honorable court. Whether my custodial interrogation is required at this stage or not. That's the whole point, my lord. My custodial interrogation, because you have recovered the 2 gold chains, seized. This is a subject matter of the first FIR. You investigate in the first FIR. That's your own objection, counter affidavit which you have filed. That's your statement. Now today, as on date, my lord, my respectful submission is that what is there to put me in custody and interrogate the matter? That is my submission for this court. Second, my lord, already the second FIR has been put to challenge by a revision petition which is pending and notice has been issued. So I make it very short, my lord. This is my call. They have filed an affidavit and their objection is the mentability. Second is that the place of jurisdiction. And I was not named. Second, I have been named. That's my submission, my lord. So my humble submission is that the custodial interrogation may not be required at this stage, my lord. That's my.
May I please, your lordship? In this matter, my learned friend has raised this question with regard to the second FIR. To that effect, I am very first deal with the second FIR. In this case, this is not at all a second FIR. This is totally separate. Why your lordship will find in my objection, I have also attached the copy of the FIR and the copy of the charge sheet. So my page number annexure A77, your lordship. As well as page number 19. Your lordship can.
This is 12. That is the first one.
First. And at page number 83, this is a distinct. As per prosecution, this is not a second FIR, distinct FIR. Now the question is, only the public servant, who is the Prayas Chakravarti working in the All India Corporation, he is the GM there. His duties and responsibility, he is having the duties of granting the tender, awarding the tender. So for all tender work, he is looking after. So in the first work, while this is 12, that is at page 77. The very first, this is a collusive trap. This is a collusive trap, wherein they are red-handed in Noida. It is written here in source information, page number 18.
So Prayas Chakraborty is common to both the FIRs.
Yes, common to both the FIR. Tender are different, parties are different. That doesn't mean that this is a second FIR. Transaction is distinct, cause of action is distinct. However, during the course of investigation, of this RC12, this larger conspiracy has come into the picture. That 2 gold chain has been given to the Prayas Chakravarti, and it is admitted by Prayas Chakravarti himself, and that has been recovered, and the voucher is recovered from the house of the Tushar Kasera. Jurisdiction for that purpose, it was in Noida, Ghaziabad. To that effect, they have earlier filed this anticipatory bail. However, I have raised the jurisdiction point, but the anticipatory bail has been made absolute. But knowing fully well, his name was not appearing. Lordship, may kindly be see 77, page number 78. Page number 78, accused name, Prayas Chakravarti, Kunal Gupta, Managing Director of United Drilling. That has to be noted. My company name is different, which is reflected in charge sheet, Your Lordship. At page 83, page 84, may kindly be. I'm giving trouble to Your Lordship. May 84. Here, Prayas Chakravarti, he is a public servant, and Tushar Kasera and unknown others. This is usually always.
Yet in the first FIR, you investigated him.
First, in first FIR, it is related to trap with Kunal Gupta while handing over a 7 lakhs of rupees. During the course of investigation, the larger conspiracy has revealed that he has taken 2 gold chain. It is reflected in their own petition, Lordship. I am coming to that.
What was recovered during the trap? That's 7 lakhs.
Yes, yes, Your Lordship. 2 gold chain was never recovered. During the investigation, it has come to the picture. I am coming to that. Their petition, Your Lordship. 8. Their petition. Telephonic communication and discovery of second FIR. The petitioner most respectfully begged to state that on 27/11/25, he received a telephone call from Sarita Yadav, an official of the CBI, who inquired about certain document pertaining to the firm, MS Industrial Trade Agency. So Tushar Kasera is running an industrial trade agency. He is dealing with the Jain work, Jain set, and that tender is of 3 crores. To that effect, he has given a bribe. This is admitted by Prayas. So because of revealing from custodial interrogation, Prayas said, yes, I have taken 2 gold chain from Tushar. Then investigating officer started another conspiracy part. So at that point of time, when investigation was conducted and seizure was made, 2 gold chain, receipt of the 2 gold chain is recovered from the house of the Tushar Kasera, from his bedroom. And Prayas Chakravarti himself said about the 2 gold chain, and investigating officer has also recovered. It is admitted by the Prayas Chakravarti. So public servant, he is a public servant. Definitely his duty is to award the tender. There are different tender. So different transaction, different cause of action. This is arising out from Tinsukia. He is the resident of Tinsukia, Tushar. And this trap was conducted at Noida, in between Prayas Chakravarti and Kunal. It is nowhere related. That is why I have already attached 2 FIR in my objection, just to compare. Lordship, that is first, 83 is the 19. Section may be the same because it is relating to the bribe. That doesn't mean that it is a second FIR, or there the same test of sameness is required. Now, I am coming here, Your Lordship. Now, FIR, second, 19, at page 85. A written complaint has been received from Sri Suraj Pal, Inspector CBI AC2, New Delhi. The copy of the complaint is enclosed herewith. Copy of prior approval of the conducting investigation VA 17A received. 17A, Lordship, 17A permission is also annexed along with our this objection. It is there, Your Lordship. 17A, it is required. Received by letter dated so and so, dated 13/8/2025, is also enclosed herewith. Information prima facie discloses the commission of cognizable offense punishable under section 61 of the BNSS and section 7, 9, 10, and 12 of the PC Act as amended against the public servant, private person, and unknown other person as mentioned at column number 7 of the investigation of this case entrusted to Mrs. Sarita Yadav. Now I am coming to the next page, your lordship. To the superintendent of police, case number so and so, so and so. I am starting from 4th line. During the investigation, a trap was laid by CBI 35. During the trap proceeding, Jyoti Kumar Singh, Deputy General Manager, MS United Rail, Prayas Chakravarti were apprehended, delivery and accepted a bribe of rupees 7 lakhs. That is a different which has occurred at Noida, and it is a collusive. The said bribe was paid to Sri Prayas Chakravarti, Sri Jyoti Kumar Singh, as his company Messrs United Drilling Tools. Our is totally different. Our company is,
Your company?
I'm coming to that. Our company is United, no, our company is, I'm coming to that. That is in 19. Yes, it is there. United Drilling, our company is Kunal Gupta, and our company is, I am coming to that, Industrial Trade Agency, your lordship. United Drill is of Kunal Gupta, Industrial Trade Agency is of Tushar Kasera, and it is run by his father. And the gold chain is given by Tushar Kasera. It is a totally different transaction, which is revealed from the first FIR during the course of investigation, that is arising out of the larger conspiracy during the course of investigation. Now I am coming to 19, your lordship. Here at Prayas Chakravarti were apprehended after delivery and acceptance of amount of rupees 7 lakh. The said bribe was paid to Prayas Chakravarti, Sri Jyoti Kumar Singh, as his company Messrs United Drilling was awarded a contract of which Machine by Oil India Limited valuing rupees 13 crores point 73, which in which Prayas Chakravarti was associated as purchase officer. Now I am coming to say, investigation case number so and so revealed that the Prayas Chakravarti had joined the Oil India Company executive trainee Prayas Chakravarti so and so, Duliajan, Dibrugarh, after completion of his deputation period in Directorate General Hydrocarbon. After his deputation, Prayas Chakravarti was assigned the work of table number 8 at Material Department Oil, Duliajan, Dibrugarh. However, by order dated so and so 4/11/2024, he was assigned the work of table number 9 on transfer of M. Bikramjit Singh, the then DGA Material, from Material Department to Project Department Oil, Duliajan. Sri Prayas Chakravarti was suspended from the service on 4/5/2025, passed after registration of this case. That during the interrogation, this is most important, your lordship, that during the interrogation in presence of independent witness, Prayas Chakravarti had revealed that he had received 2 gold chain from Tushar Kasera, son of Pradeep Kasera, on 12/4/2025. So this is while interrogation was going on in RC 12, Prayas Chakravarti revealed. 12/4/25 at Tinsukia as illegal gratification for favoring the firm Industrial Trade Agency owned by Sri Pradeep Kasera against a tender worth rupees 3 crore for supply of genset award to MS Industrial Trade Agency. Sri Prayas Chakravarti has processed the said contract. He said the said 2 gold chain has been recovered and seized by CBI. This is also recovered on 3/5/2025 in presence of Prayas Chakravarti and independent witnesses. Admittedly, the signature of Prayas Chakravarti must be there in the seizure list. Investigation has revealed after the due approval of the competent authority, the mobile number of Sri Prayas Chakravarti and other were intercepted. The recorded interception call conversation held between Sri Prayas Chakravarti and Sri Tushar Kasera, as well as other document collected during the investigation, has a prima facie established that Prayas Chakravarti had demanded a illegal gratification bribe from Sri Tushar Kasera in lieu of tender number so and so dated 7/6/24 for rupees so and so awarded to Industrial Trade Agency of supply installation of commission of 3 number of 250 kVA.
All right. Just one thing. This is in relation to 12. You are reading it page 86 onwards.
This FIR is in relation to 19 because thereafter the charge sheet has been filed, your lordship. Charge sheet is filed in 12. Charge sheet is filed in 12, your lordship. Page number 84 is showing Prayas Chakravarti, Tushar Kasera. Page number 84. This is in respect of 19. In the 83 top, it is written RC 2172025A0019 dated 18/8/25. This was registered on 18/8 on the admission made by Prayas Chakravarti that he has also received it.
When was charge sheet filed?
Charge sheet has been filed in 12.
When?
It's filed, it is with me, Your Lordship. I am coming to that. It was filed on 3/5/25. FIR is there. Final report dated 7/25 July. Date 27/6/25. It is written there. Page number 92. It is there, Your Lordship. I have already annexed. Page number 92.
27/6/25.
27/6/25. In this, Tushar Kasera name is not there. It is totally related to accused number 1, public servant Prayas Chakravarti at page number 93. Page number 92, private person named Jyoti Kumar Singh. Kunal Gupta, 3, page number 95. Page number 96, private person, that is a company has arrayed as a party MS United Drilling Tools Limited. So this portion is not dealing with the bribe of Tushar Kasera. Tushar Kasera is arising out of bribing, which is revealed from the interrogation of the Prayas Chakravarti in the matter of trap. That is a collusive trap. That is-
Even in this page 86, 18/8, this is the complaint.
Yes, Your Lordship.
Yes, it says investigation of RC 12 has revealed that Prayas Chakravarti so and so that during interrogation in the presence of independent witnesses, Prayas Chakravarti had revealed that he had received 2 gold chains from Tushar Kasera.
Yes, yes. From the
During
charge-
interrogation means how many times was he interrogated? It was in connection with the earlier one itself.
Prayas Chakravarti was interrogated when at the time of registration of RC 12.
Yes.
From his mouth, when it is revealed that investigation is complete, when it is revealed that he has taken 2 gold chain, when it is recovered from his house, then this FIR is lodged, that is 18/8/25. Charge sheet is not yet filed. 18/8/85.
Yes, I'm reading 18/8/25.
Yes.
Yes.
So
Here itself it is written during interrogation of Prayas Chakravarti, he had also revealed this part also,
Your Lordship.
2 gold chains. So why was he not included earlier in that charge sheet?
In that investigation of 12,
Yes.
when investigation of 12 is going on, at that point of time, he revealed that he has also received 2 gold chain.
Yes.
So after filing that charge sheet and subsequently and
So
signing,
why was he excluded from the charge sheet, this petitioner at that time?
because it is a distinct offense, separate charge sheets, cause of action is different, jurisdiction is different. That was trap done in Noida. This is here at Tinsukia. And this is relating to the this is relating to the Industrial Trade Agency. Everything is different. It cannot be said to be the same FIR. Same ingredient in both the FIR, totally different. Party is different, company is different. It is a bribing case, section 7, that is a trap one. And for that purpose, jurisdiction is a special judge Ghaziabad. And for this purpose, this is Guwahati. This is of Tinsukia. Recovery is made at Tinsukia. That voucher has been recovered from his house, Tushar Kasera's house. In no way it is related to the first FIR. And the first charge sheet has already been filed, wherein Prayas Chakravarti, Kunal Gupta, Jyoti Kumar and their company United Drilling has been made party. So this is the part of larger conspiracy, Your Lordship. This is totally part of the larger conspiracy. It cannot be clubbed together because transaction is different, tender award is different, party is different, company is different, Nature of the offense is also different. That one is a trap. This is a bribing. That has been revealed from the mouth of the Prayas Chakravarti. In my objection, both the FIR, it has been attached. Complaint is also attached. Charge sheet of the first FIR, it is not first FIR. FIR in respect of Prayas Chakravarti and Kunal is also attached. Nowhere it is same. If I'll come to their petition, your lordship, I am reverting that also. They have.
Chain was recovered on 3/5/25 and the complaint was filed after 4 months.
Because they are investigating, they may get something more. Because these are the part of transaction
Yes,
and it
anyway.
is going on.
Yes. Yes.
And still Tushar Kasera, whenever notice has been sent, CD will reveal. In his address, notice has been sent, your lordship, and the address is given by him. And same address, this is no such address. Address is Sri Tushar Kasera, son of Sri Pradeep Kasera, resident behind petrol pump Mahakumbh Road, Tinsukia. In petition, your lordship, their petition, this address is written, but this is returned. And he's taking, here it is written, note is there, no such address. Then thereafter, investigating officer has given in different address. In track, page number, this is 15, report 15 will say, the track is speaking that it is delivered, he is not coming for interrogation. Only because this is pending. Page number 15, I have already marked. In compliance with the notice under section 35C BNSS bearing number 69 dated 7/1/26 issued to accused Tushar Kasera, he was supposed to report this office on 12/1/26. Since the notice sent to him has not been returned to this office, the postal tracking record were checked. The tracking record revealed that the notice was not delivered as no such person reside at the given address. It is pertinent to mention here in that the notice was sent to the address provided by the accused Tushar Kasera, and the same address where no such person is available, this address is given in the petition itself. That is by way of affidavit. He is avoiding the investigating officer, not cooperating. It is pertinent to mention here that the notice was sent to the address provided by accused Sri Tushar Kasera in the petition filed by him in the Honorable Court of Guwahati. Now I am coming to other, your lordship, CD. Notice under section 35(3) of the BNSS bearing number 4542 dated 23/12/2025 issued to accused Tushar Kasera has been received back as it was not delivered. Marked address not found. Notice will be sent to different address. Issued notice under bearing number 69 dated 7/1 to Sri Tushar Kasera with direction to attend this office. Copy of the notice is enclosed. Again, he has not reported. Now I am coming to other notice. In exercise of the power of so and so, so and so, it is revealed that there are reasonable ground to question you to ascertain the fact so and so. You are directed to comply with all and all or the following direction. These are the direction given to him on 7/1. He has not appeared. And the address in which the file noting is there, envelope noting is there by the postal department, such person is not available. Whereas by affidavit, same address is given in the petition. It is very strange. He doesn't want to cooperate. Here is the, we have given the envelope also. Here is the envelope. Now I am coming to the second, with regard to the, whether it will be treated as second FIR or not. I am coming to that, your lordship. Because my learned friend has taken that plea. They have taken in their petition, at their petition page number 10, they have relied the test of consequences, Babu Bhai, test of sameness, Babu Bhai state of Gujarat. I am giving your lordship the Babu Bhai state of Gujarat. And the second one also, Amitav. दोनों दे देते हैं. Second page, your lordship, para D. Babu Bhai, second page. Babu Bhai, State of Gujarat, second page. Para D. In case of subsequent FIR, the court has to examine the fact and circumstances giving rise to both the FIR, and the test of sameness is to be applied to find out whether both the FIRs related to the same incident in respect of the same occurrence or are in regard to the incident which are two or more part of the same transaction. If the answer is in affirmative, the second FIR is liable to be quashed. However, in case the contrary is proved, where the version in the second FIR is different and they are in respect of the two different incident crimes, the second FIR is permissible. But in my case, your lordship, it is not at all second FIR. But even if it is assumed, this citation is not at all applicable in this case, which is given in there. They have relied in page number 10. This is Supreme Court judgment. Then I am coming to para 13. Para 13. Para 13, your lordship. Page number has been given 262 in the corner left. Corner left, 262, page number.
Yes.
In Ramlal Naurang Estate, this court considered a case wherein two FIR had been lodged. The first one formed a part of a subsequent larger conspiracy, which came to light on receipt of the fresh information. Some of the conspirators were common in both the FIR, and the object of the conspiracy is both the cases was not the same. This court, while considering the question as to whether investigation and further proceeding on the basis of both the FIR was permissible, held that no straitjacket formula can be laid down in this regard. The only test whether two FIR can be permitted to exist was whether the two conspiracy were identical or not. After considering the fact of the said case, the court came to the conclusion that both the conspiracy were not identical. Therefore, lodging of two FIR was held to be permissible. It is totally matching with our case. And they have also relied. I'm coming to that only. It is relied by them, this citation. Now I'm coming to para number 19, your lordship. Page number 264. Shall I go through? Para number 19. The court held as under in Nirmal Singh's case. The second FIR, in our opinion, would be maintainable not only because there were a different version, but when new discovery is made in factual foundation. In our case, there is a new discovery because it has come from the mouth of the accused Prayas. Discovery may be made by the police authorities at a subsequent stage. Discovery about larger conspiracy can also be surfaced in another proceeding, as for example, in a case of this nature, if the police authorities did not make a fair investigation and left out conspiracy aspect of the matter from the purview of its investigation, in our opinion, as and when the same surfaced, it was open to the state or high court to direct the investigation in respect of an offense which is distinct, separate from one for which the FIR had already been lodged. This is totally in our favor, your lordship. Same fact. Now I am coming to, these are the relied by them. Now I am coming to Amitav. This is given from my side. These two, they have relied, but it is, I have rebutted the same from their own citation. Now I am coming to Amitav Aninchal sir. This is the first head note will speak, your lordship. This is a very citation. हम दिए हैं ये उन्हीं का है उनको कौन सा बिलोंग A2 sorry
Already here.
I have already given two. This one, lots. This was my copy. The first page itself, the second FIR, second paragraph, first page. The second FIR in respect of same offense or incident forming a part of the same transaction as contained in first FIR reiterated is not permissible. Second FIR for an unrelated incident and for offense of such magnitude which does not fall within the ambit of first FIR is permissible. So my case is not falling under the ambit of the first FIR because transactions are different, tenders are different, company is different, private person is different, maybe public servant is one and the same, but his duties and responsibility assigned to this work. So definitely he is looking after all work. So here it is matching with our case. The first FIR lodged by the it is narration of the this case. So for the offense of such magnitude which does not fall within the ambit of first FIR is a permissible. And in Amitabh Anil Chandra Shah, the first page, which I have given earlier, Your Lordship, the first page itself says, the second FIR, when permissible, different offenses committed in the same transaction or offense arising as a consequence of prior offense, applicability of consequences test laid down in C. Muninappan 2010 SSC is stand taken by investigating agency at various stage of investigation, court proceeding, investigating agency when stopped from changing its stand, prejudice to prosecution case in case of second FIR is quashed. Relevance, new information coming to light as an investigation progressed. Two multiple FIR warranted or one FIR with supplementary charge sheet in the first FIR. This is also saying the same.
All right.
Now I am coming to other citations. So,
Saying what?
yes, other
Saying
citations.
what?
Other citations are
The sake of citation or anything new?
anything. No, if these are earlier citation, I can furnish page number and everything is written. That is with regard to the serious fraud investigation of the Aditya Sarda, Devender Kumar Bansal, and the most important is pitching.
Yes, I have. Yes, you need not bother. I have all those from your earlier case with me.
If
Yes.
your lordship wishes, I can give your lordship. I have the copies for your lordship convenience.
All right.
So my humble submission is that this is not at all a second FIR. From there, petition itself.
What about need for custodial interrogation as of now?
Yes, because
After
it's-
recovery of the chains and you have recovered the
Speak the
voucher,
truth. CD will speak the truth. He is not appearing.
he is not.
Not appearing, even after given the notice.
No, he will appear even if we grant him privilege of
But
pre-arrest
he is
bail.
protected, he is not going to reveal the thing. To unfold the truth. There are number catena of cases to get the
You have
quality.
already unfolded the truth. What more would you get from interrogating him? You have recovered the chain, you have recovered the voucher from his house.
But it may happen if he will be interrogated, something else will come.
Even if he confesses, that will not be admissible.
But on investigation, if it will come out,
What will come?
if his confession is not admissible, but if he confess something and the police will go and investigate it.
Fishing
like in
expedition.
Earlier case, this has come out. Like in earlier case in Prayas Chakravarti Kunal, this has come out. From his revealance, another thing will come out. So it is the public property and the related to the economic offenses, and the Supreme Court has always treated the economic offenses in the different footing. And the very serious view has been taken by recent past by the Supreme Court to check this offenses, economic offenses.
Yes.
So, I am giving with the list. Right. Seven. Fix है ना पुष्पजीत का? I have listed all this thing and citations are there with the page.
If you reply, if my learned friend has finished this 2 minutes, I'll just give a reply. These, I think you're finished. My lord, these all the judgments which my learned friend is placing before the court is regarded about the whether revisional power of the court, whether questioning of an FIR. We are not a question. Your lordship has asked a very pertinent question, whether his custodial interrogation is required or not. Whether after passing of the order on 3/12/2024, 5, my learned friend said that I have not cooperated. But I am to say that I have cooperated because I'll just give my particular flight which I travel. CBI's, my lord, entry is also there. After the interim order was passed by this court. Please look into it. Why my learned friend is saying that I did not cooperate even after passing of this order by this court. They sought for document that also I have given. Kindly see, my lord. Kindly see. This is where I travel after the interim order was passed. Thereafter, when I have to go to CBI office, there has to be an entry of visitors. This I have done. And I have taken instruction from my client and they said that I have cooperated with the investigating agency.
CD should reflect it at
Yes.
least.
I have already.
Now, my lord,
Lordship.
today,
This is returned
no, one
and
second.
the same address is there. I
No.
have already marked your lordship.
My lord, today what is my two gold chains recovered? It has been seized. It has been seized. What is that? Well, I am asking myself, what is that new discovery they have made? What is that new discovery they have made? Whether they have mentioned in the FIR new discovery they have made?
No, they haven't made a new discovery. They hope to make one.
They made, my lord, that will be endless. That will be endless, my lord. That will be, and I will cooperate, my lord. It is not that I am giving undertaking for on behalf of my client that yes, my client will cooperate. That is not that why he will not cooperate with the investigating agency, my lord. He'll cooperate. Well, I made, your lordship has seen in the first FIR also, I traveled and I annexed those plane ticket. I cooperate with the investigating agency. That was closed. Second time also interim bill was granted. I traveled to Delhi. My cooperation is there. I will not run away, my lord. Any condition that may be imposed, I will definitely cooperate, my lord.
In RC12, where you were granted firstly interim protection.
Interim.
After that, you appeared.
I appeared. I appeared in Delhi.
In RC12, you appeared.
RC12, I appeared. Thoroughly, it was investigated, my lord. I appeared. And that was a part, your lordship was, I think, that page 72, that on 3/12/2025 itself, these two gold chains were recovered. And they were seized. On that 3/12/2025, my lord will kindly see at page 71. Page 71.
No, 3/12/25, there was this condition number 1. Petitioner shall appear before the IO within 10 days.
Yes.
From today.
Yes.
Has that happened or not?
Yes, please see, my lord.
But the notice is.
My lord, see, kindly see.
No, why would you need to send a
Subsequently, they have
notice?
not appeared. Subsequently, they have not
This
appeared.
is what they are
These
saying.
Month of
I'm
January.
literally saying I am
That
not appear
order of
at
the
all.
court has been complied with. That is what I am
Yes.
asking.
Why is saying, my lord, whether I have
That was
complied or
earlier
not?
in respect of 12 year lordship.
No, kindly
No,
see.
in this case,
Yes.
I am
This-
reading the order passed in this case.
This is your receipt, I am saying.
But CD is there.
CD will, this is my, that
No,
is I-
CD, investigating
you may
officer
say, I
cannot
cannot
lie.
do.
At any point of time, investigating officer cannot lie.
My lord,
It
please
is a
look
case
into
diary.
this.
It is the part of the record. It would be a very serious issue if there will be any misrepresentation of fact. And when envelope has returned, remark is there of the postal department. Appearing once is not sufficient for the purpose of investigation. It is related to a public sector company where the public money is involved.
This order was passed on 3/12. So 10 days from there on, it would be 13/12. Is there any entry during this period? I don't find any.
Yes,
in your
January
case
entry
diary.
is there. January entry is there, your lords. In 15. Entry 15, January entry is there. All I marked with regard to the January entry. And that envelope has returned. And the address which is given in the envelope is the same address in the petition. No such person found, it is written. Addressee is not found. Tag mark is there. These are all of January.
Twelve, 12:25.
Yes,
Sri
that's the
Tushar
one.
Kesera
Yes.
appeared before me at 12:55
When?
PM as I hope the case was not
After
present.
your lordship, thereafter,
This is
thereafter.
This is within this period of 10 days.
Ah,
He was
10
asked to
days.
appear, he appeared. How can you fault him now?
Thereafter, the investigating officer has summoned him.
This is why
He
you
has
are
not
telling-
appeared.
Please tell the court the truth that whether I
It is there
appeared.
in the-
You said that I didn't appear at all. Don't say all this.
No, I'm not saying that he did not
No,
appear.
you said that I didn't appear at all. Why you are saying I
never
appeared?
said- I
I
never said-
appeared. Subsequent may be different, but with persons, courts order I complied within 10 days. Why you are saying that? We are representing only our clients, nothing personal involvement in any of the case.
Telling with regard to the return of
Yes.
the envelope when the
No, but
notice has
is,
been.
I have
it is not
appeared.
in the CD.
I have
Beyond the
appeared.
CD.
You have said beyond the CD, you
No,
have
I read-
appeared.
I read out.
Yes, the judge has said, my lord has looked into it. In persons, a court order appeared.
Yes, go on. So are you saying about this envelope? No such address. Different. All right, yes. Anything else?
Submission that their petition is not maintainable at this stage because the grounds whatever they have taken with regard to the second FIR, that is not at all applicable hearing. And he is not appearing subsequently whenever the notice has been served as reflected in the CD. And no protection has been granted to the petitioner at this stage.
All right. Save it. Keep your place.
Macam lah je.
Zero. Separate.
Diary was called for classification.
My lord, CD not received yet.
Interim is there.
No, Lordship.
First date. Where is this from?
So that will be given.
All right. What did it do? She did not receive list again.
It was called for lordship.
CD received. CD received, but CD is not up to date. Up to date till 31/10/25. Earlier rejected. There is no new ground now. Yeah.
If seizure has been made, lordship. Main point is seizure and test has been conducted by the. Suppose no seizure has been made, lordship.
You are the jeweler or the valuer?
I am the
Valuer,
loan approver, lordship.
approver.
Approver, not lordship. I have taken the loan, lordship.
You are the borrower. So if it is rejected earlier, on what ground do we allow now? Is pre-arrest bail.
What's a previous bill? What's a update CD maybe call for lordship
Alright.
with the
Up-to-date
seizure and
CD
the
is not available. Call for the up-to-date CD. Please again on.
also with the test report also. The list and test report also. Because I have tried
Including the seizure list and test report.
after rejection, I have approached the CJM lordship to find out if any seizure has been made, lordship. Obligation.
Take delay. 30. 13 to delay. No?
CD is there.
Is here, madam. The CD is here, but the thing is that here item number 37, my lord. 37 and 41 are connected, madam. The petitioner was given interim. After that, madam, I have not found his statement, madam.
He has appeared
But statement is not here, madam.
immediately on the next day.
70.
That CD has been received, but it appears that the same is not updated as it does not contain the statements of the petitioners.
Now, item number 37, madam.
In item number 37, we are dictating. Call for the updated CD, interim order passed earlier to continue.
Public.
And what about other case, 41?
No, 41 to Mono.
What happens in 41?
41, lordship, I am appearing for 41.
What happened there? Same,
Yeah, my lord, there was no interim order.
no interim order.
But otherwise, my lord, both these petitioners are similarly situated, so it will be better if.
Lordship, all the, so far as this case is concerned, nothing has been recovered from me. Only my vehicle, this bike and motorbike and one vehicle was
You
recovered.
are protected, but
Yes,
what about him?
Yes, Lordship. All
What about
others,
you?
already allowed bail.
Lordship, my,
He wants to.
Lordship, similarly situated,
Look at that.
Lordship.
Next date.
Seated.
Is this matter along with I got to DDB
Lordship, in the interim, if
2936 of 25. Maybe. On 16.
Lordship, in the interim, till date, Lordship. Action may be given, Lordship. Similarly situated, Lordship.
No, my lord, his
Lordship,
kettles were recovered from his place, my lord.
My-
Yeah, the initial first day, my lord, the interim was not considered, my lord.
Lordship, the prosecution case is that 13 numbers of kettles were recovered.
Anyway, in the first day it was not granted.
Lordship.
So
Oblige, your Lordship.
Wait, please, Lordship. Try to contact petitioner, but we were unable to contact the petitioner, so adjourn for to the Lordship.
CD received, Lordship. The order dated 15/12/2025. He appeared, Lordship, interim was granted. He appeared, his statement is recorded, but Lordship is not cooperating with the investigation. As Lordship, 94 of notice under section 94 of BNSS Act was duly served upon the accused person, during him to produce his mobile phone, which contains the nude photographs, video of the victim, as well as digital evidence relating to the offense, and also to submit victim's document. However, the accused has deliberately failed and neglected to comply with the said lawful notice and has not cooperated with the investigation.
he has not submitted what? The
Lordship, the documents, Lordship, and also the mobile phone, Lordship, which contains the nude photograph and video of the victim. Also, victim's documents, Lordship. Aadhaar card, PAN card, voter card, everything. And Lordship.
yes, what do you say?
Try to contact the petitioner, but we were
Will he do?
kindly adjourn the matter to the another day.
Head of Learned Counsel for the petition. This is the matter again on. When do you want? CDB retained,
Lordship, short date, Lordship.
retained or returned? Retained.
Retained.
Okay.
2nd of February.
May I please, Your Lordship. It's a pre-arrest bail application, Lordship. There are two petitioners, they are husband and wife, Lordship. Lordship, they were granted interim bail on 18/12/2025, and they have appeared before the IO, Lordship. Their statement has been recorded, Lordship. And the main section is, Lordship, 69 of the BNS, Lordship. FIR, Lordship, will find the translated copy at page number 11.
Is recorded, Lordship.
Here is the FIR, Lordship. Page 11.
Yes, what did you say?
His statement. Both petitioner Lordship statement recorded Lordship. And Lordship, after examining the complainant and witness, it is revealed that the accused person was in relationship with the complainant's daughter, Lordship. Relationship was there, Lordship.
That is there in the FIR, Lordship.
Also.
That is a
to
relationship was
state
there.
The witnesses, Lordship. That Lordship relationship.
Dated 18/12/20. As per the FIR, the petitioner had love affair with the victim aged 24 years, in course of which they developed physical relationship. Subsequently, the petitioner taken away the victim.
Petitioner number 1, Lordship.
Prisoner number
There are
1
two
had
petitioners.
taken away the victim. Taken away the victim on 27/11/25. His house, but the intervention of the petitioner number
2, Lordship, is the wife.
is the wife of the petitioner number 1. Don't say intervention. Promising to marry her, but on the next day, the wife of the petitioner, that is petitioner 2, went to the house of the petitioner and humiliated the victim and physically. That petitioner number 1 or marry the victim. It is submitted that the petitioner number 1 and 2 are husband and wife. The story as alleged in the FIR is fully concocted. Pursuant to interim protection granted by this court, the petitioners have appeared before the IO and their statements have also been recorded. Having regard to the nature of the allegations, the fact that their statements have been, the statements of the petitioners have been custodial interrogation of the petitioner may not be necessary. Arrest bail is allowed. The order of temporary arrest bail dated 18/12/25 is hereby made at order provided that the petitioner shall cooperate with the investigation. Instance disposed of.
Obliged.
We did not receive lordship.
Short date may be given, my lord. From kept, yes, my lord. Second time maybe, my lord.
We did not receive list again on
Two.
Obliged.
Diary was called for on the last occasion.
Diary we have received, lordship.
implication of the petitioners.
Lordship, I have not found any implications.
Hmm?
I have not found any implication, lordship, in the same. Take it also.
Third learned counsel for the petitioner, additional PP. This is an application. Paragraph 2. It's been like boot के भी दिया raw materials. CDS called for has been received and upon perusal of the same learned additional PP submits that no material is available against the
Lordship, because lordship, sometimes what happen on the basis of this order, they came for quashing also. So lordship, till that no implications.
as of now. Having regard to the above, therefore, pre-arrest allowed petitioners in the event of his arrest. 50,000 to securities. Cooperate with the investigation.
Deeply obliged, your lordship.
Forty-four is also same.
Every
Same
day,
lordship. For stolen of for 6 numbers of UPS battery from ATM, there is also no implication. Also. Here also 3 persons have been arrested, but they have been mentioned the this person.
As per the para 2 আগত to the same order in case of para 2 as per the FIR 6 numbers of UPS batteries were stolen From the ATMs,
Yes, Lordship.
the ATMs of SBI. Near NEF College. Mati. Full stop. Same like the previous one.
Lordship, surety, Lordship. Surety amount, Lordship.
50.
Deep level, Lordship. Forty-six, we have not received the CD, Lordship.
My lord, this is a simple case, my lord. He want to surrender because these 4 teenagers, 5 teenagers, they were instructed to leave the place. They were in drunken state, so they assaulted this police party, my lord. And already one has a granted bail, other is arrested, my lord. On ground of arrest, my lord, this they want to know the understood the motive, my lord. Page 17 and to catch the other culprits, my lord. They are unarmed, my lord. These are armed policemen, 7 on 9s. They are instructed to leave this place. They have not done. My lord, others bailable offense only robbery charge was brought and the grievous injury. That is the thing, my lord. Others. So at this stage, my lord, 50 days he is out of law. Teenage, my lord, 25 years, my lord. Without arms and make a party. 11:30
We
police
must
party.
have heard all that before on the first occasion.
Yes,
itself.
my lord. So, my lord, let them he may surrender, my lord, with condition that if he not surrender, the case interim bail may be granted. He want to then CD will come, my lord. So, my humble prayer is that only.
What kind of prayer is that? The date for CD.
Court date may be given, my lord.
Just give us short date,
Nine-
second
nine-
time.
6.
Second time is correct. But
He said. Anappearance.
Can copy not received. Can copy of TCR not received. List again on so and so interim order passed earlier. Continue. Still doesn't fit. Is this I? Nobody appears.
Earlier also non-appearance, Lordship, probably.
None appears. List again after 4 weeks. If any date. If they just 4 weeks করে থাক লাগিলে নিজে উঠাই লব
This is check bouncing matter, Lordship, appeal against acquittal of the accused, Lordship. We have appointed amicus curiae in the case also, and we served the copies. The matter has come up for today.
not available.
Actually, someone, Lordship.
Attorney Demicus Curie, who is the
Priyakshi Das. Priyakshi Das, her name was.
This, but this Priyanki Das is not present. Is the matter again on? This.
Yes, my lord. Well, the petitioner before your lordship is a professor and working in the Department of Chemical Engineering and also the Dean of Research and Development at IIT Guwahati. And he is holding many international posts that is already described there, my lord. Now coming to the backdrop of the case is that the informal lady, my lord, a major, she has filed a thing that he has touched my hand, my lord. And that is the main reason why the FIR has to be filed and belatedly. I have got prepared the list of dates, my lord. दुनिया से कोई को दिल का कुछ नहीं second lot to Tahsil to so So, my lord, it started from 2/11/21, my lord. The informant opposite party number 2 approached the accused petitioner via email, requesting the accused petitioner to be a mentor and guide up for a startup journey. He wanted the formula actually, of which he is an expert. He did not share it, and which he could not also do it, my lord. So that was the bone of contention. He wanted it at all costs, and I never parted with it. And for that, without calling, when I was busy in a conclave, my lord, that which I've annexed it at the last page, if your lordship will see, that Northeast Research Conclave was going on since May 20 and 22. Then she just dropped in without informing me, and she came on her own to have a chat with me and all. I could not give time. And when I was going on my way to the trophy shop that is situated at Ulubari from IIT to purchase the mementos for the delegates, my lord. Then she accompanied me in my car, and while coming towards the vehicle at that time, road construction work of the Maligaon Bridge was going on. So there was heavy rush, bumper to bumper. And when they reached Ma Kamakya temple, my lord, my accused asked her to pray before the deity, my lord, from the roadside itself. And in that protest, he only touched the hands, my lord. Not inappropriately, my lord. Page 36. 35 it started, I believe. 36. From 36 is the contention, my lord. Shall I read, my? I am Anushya Vyas, a resident of Ahmedabad, Gujarat. I am writing this letter to file a complaint about the harassment I had faced in Guwahati. This is to inform you that I have been harassed by Professor Bimal Katiyar, that's the accused petitioner, Dean Research and Development, IIT Guwahati, on 18 May 2022. The incident took place in Professor Bimal's car on the way between IIT Guwahati and Baptist Church, wherein he came to drop me to my friend's home located near Baptist Church, Fancy Bazaar area. The details of the incidents are given below for your kind information. I was working as my startup idea and was incubated under Atal Innovation Mission at AIC Such Ahmedabad. As part of the journey, a mentor plays an important role to guide and give the right direction. I was looking for an expert
and a mentor in the field. I was working in and so I contacted Professor Bimal Katia, Dean and Research Development, IIT Guwahati. He agreed to mentor me, but he asked me to work under the guidance at IIT Guwahati. My father and I visited Guwahati in January 22 to discuss further. He offered to be the partner in my company and assured me that he will provide me support in every way to launch and grow my company. We discussed and decided that I will work under this guidance at IIT Guwahati. He even assured my father, saying that your daughter is like my daughter. He even mentioned that the reason he wants to support me is my determination and patience, as a very few have this. Now the main parameter. On 18 May 2022, I visited IIT Guwahati and one day changed everything. He was very busy that day as he was the convener of the NERC, which was held between 28 May to 22nd May. He asked me to sit in his office and I waited the whole day. Then he offered to drop me at my friend's home near Baptist Church as I was staying there. My friend's home is in the city area and the IIT campus is located on the outskirts of the city area. He offered to drop me in his car by mentioning that he had some work to be done in the city area. We left the IIT campus around 6 to 6:30 p.m. On our way, he started saying wild things. He asked me to show my palm and started looking for the lines in my palm and said that it is a sign of good luck and prosperity. I was really surprised by what he said, and I replied saying that one thing, that I don't believe in lines and luck, but I believe in hard work. There is a Kamakya temple in Guwahati city. He stopped the car at the entrance and asked me to join hands in front of goddess as a new beginning of the journey. Then held my hands, which made me uncomfortable, and holding my hand, he asked me to say that he will never break our trust. I was still confused and was able to process what was happening. I neglected thinking that it may be his way to start the new beginning. On the way, he again held my hand, and even while driving, he kept holding my hand. I was very uncomfortable and I did not expect this kind of behavior. He held my hand not once, not twice, but many times. In the car, and somewhere knew that I was uncovered, so he asked me whether I was hesitating. He mentioned many things which was surprising for me. He even said to me that he now is emotionally attached with me and he will never leave me in between. And he continued by mentioning that it is fine that if you are attached with me emotionally, but I will connect with you emotionally. I am crazy, right? This is what he told me. He insisted on having dinner or coffee. Even after denying, he kept on insisting. He also gave me an option to stay in a hostel, guest house, hotel, and not
Alright, I
once.
have finished.
So, if your lordship will look into it, my lord, there was no outpraising of the modesty in any format, my lord. And the IIT, my lord, before the IIT, prior to the coming to the filing of the FIR, my lord, she has filed a complaint before the IIT authority, which is Annexure 4, page 42. And they conducted an internal inquiry, my lord. And what they find is already mentioned at page 46 also. 45, 42. Fact finding is 55. My lord, the fact finding where the complaint was lodged is basically at Annexure 5, page 55, my lord. A high-level committee was constituted that it was whether a sexual assault or anything as such, my lord. After visiting brief facts evidence filed by Anusha Vyas, there's a informant and also statement WhatsApp correspondent with the complaint committee found that the complaint filed by Vyas has no merit or substance based on the evidence submitted by both the parties. and subsequent independent interaction with both the parties, the committee finds that the faculty member has not done anything wrong with Ms. Anushka. When she was unsuccessful here, my lord, then she filed the FIR, my lord. After how many months?
About a year.
So almost about a year, my lord, thereafter of this communication, the informant filed the FIR. So in the last, in conclusion, the complaint filed by Anushka sir is concocted and has no merit, and thereafter no further action is required from the institute side. That is the DP one way, my lord. And during the investigation of the case, my lord, he was granted anticipatory bail, my lord, and he complied with all the conditions, therefore, my lord. Lordship want to see, my lord, we can look into the 164 statement number, Annex 7. There is variation also. Page 63, my lord. And before starting, just I'll point out, my lord, same day 164 was recorded without examining and without same day the FIR itself was filed. On 38th June 23, the victim girl's statement was recorded. And immediately after recording, my lord, if your lordship will see the date of the charge sheet, my lord, there is on the same day, the which I am coming up for quashing, my lord, is also filed on the same date, my lord. At page 2. At page 39, my lord, can have a look, my lord, the date, which shows, my lord, that the police is also not acting fairly, my lord. Because as a routine manner, the charge sheet has been filed. Next.
Yes.
So, my lord, taking all the facts into consideration, my lord, but this asset to the nation, my lord. So I think, my lord, it's a fit case wherein your lordship should.
Ingredient is.
And the ingredients necessary, and I've got certain decision, my lord, my bullet points which I'd like to points with it.
This would be.
Okay, points of argument. here. I just given my bullet points, my lord. It will start from para 3, my lord. The victim on 27/5/22 filed an official complaint against the accused through IIT portal and email on the same allegation, which is the subject matter of the same FIR, my lord. That the victim was heard on 17/10/22 through video conferencing, and the accused was heard on 21/10 in person. The accused on 19/6 filed the show cause reply. The victim received the decision of the outcome of the departmental proceeding on 24/11/20, and the FIR was filed by her on 11/2. That is after almost 2.5 months, not 1 year, sorry, man. 2.5 months when she failed to get a favorable response in her favor, madam. 1 hour, 1 year of the incident. The FIR was filed. The accused was given a clean sheet in the departmental proceeding conducted against him on the same allegation charge. Allegation are same, my lord. As the informant victim could not effectively do any harm to the accused player,
So out of the vindication, filed the FIR of the case to harass and teach him a lesson. Victim state's record was on 13/6 under 164, and on the same day, that is on 13/6, the charge sheet was filed, my lord. That the accused did not share the technology formula biodegradable for her business purpose at any cost, and as such she bore a grudge against the accused, for which she has filed the present FIR as a vindicative measure. That the informant victim on 18/5 without any prior intimation, because I was busy with my conclave, which I am the in charge, my lord. Such a huge world-based conclave, my lord. All international participation has come, my lord. I have annexed it, my lord. So in that way, sir, why will I called her? Without calling her, without inviting her, she just came in. And I made her sit along with the father. So in the process, something has happened. Now she is trying to implicate me by that I have touched. The accused was the convener of Northeast Research Conclave. The accused, after complying his officer, started his journey towards the city for buying memento at B. Borua College Road, and the victim girl wanted to get dropped in the city, and on a bona fide intention, the accused agreed to drop the opposite party. At the relevant time on date 8/5, the construction of Maligaon flyover was going on, and there was heavy rush on the road. And if the accused had actually done any bad act upon the victim, she could have easily raised the hue and cry and get out of the vehicle, which she did not do so. Rather, she continued to accompany the accused to the city. And as per her allegation, my lord, I dropped her near the Baptist church. Near the Baptist church, there is a all-women PS also. It's just taking judicial notice. My lord, that the sex in the instance here, there is no whisper at all that the accused has done any sexual activity and or has made any sexual advance or a gesture to outrage the modesty of the informant. The reaction and conduct of the woman are also relevant to determine a case registered under section 354 IPC, my lord. That from the attending circumstance, from the uncontroverted allegation made in the complaint and in 164 statement, it is evident that the victim girl bore a grudge against the accused for not parting with the biodegradable former for a startup business, and as such, she has wreaked vengeance upon the accused petition. So these are my basic points, my lord, and I have elaborately mentioned in my petition all the facts which will be necessary to determine the case, my lord. My lord, he has got this, professor has got, with all respect, my lord, 30 patent in his name regarding that because IITG was able to develop the PP kit, my lord, at that time, my lord, COVID time, my lord. This is where the formula and how to now make it perish without burning it or something, so that the atmosphere is not polluted, my lord. They are working on that, my lord. আগত দিলা একটু দিদি পিন মারা আছে পিনটো দি দিয়ক আগতে এইখিনি দি দিয়া এইখিনি next.
It seems they met only twice. Once
Twice,
when she
twice,
came with her
twice.
father, and then when she
Yes,
came alone.
she came on her own. And my lord, I will not trouble your lordship, but has given as I could lay my hands, my lord, to certain judgment propounded by Honorable Supreme Court. If your lordship will see necessary requirements of ingredient of section 354, Honorable Apex will refer to the case of Radu Pandegala. So shall I read, my lord?
It's okay, we'll see.
It's all, I have quoted it, your lordship, with numbers, if your lordship, just for convenience sake. First judgment is 1, I have marked it. Second is 2, that wise, your lordship can compare with the index, my lord.
Yes.
And one para which I'm tempted to read, my lord, by the criminal event. One judgment coming very recently from the Meghalaya High Court, but relying on the Supreme Court. In the same case also, one lady tried to victimize the doctor, my lord, gynecology department. Then your lordship, by relying on a Supreme Court judgment, this was propounded and it was decided that needs to be quashed, my lord. I'm just reading that part of the para, my lord. Yeah, mere. No, mere touching. Now, when there is no ingredients, the Supreme Court said, then the continuation of the criminal proceeding will be an abusive process of the court, my lord. That your lordship is at page para 4, my lord.
Which judgment?
My lord, actually, it will serial number 9, my lord.
Serial number.
Yeah.
There is no serial number 9, NZ8.
Athan Santa Singh. Last judgment, my lord. Probably number has not been. From Meghalaya, I have got the book with me, my lord. So he says that the apex code in the case of
Santa Singh.
Professor para 12, my lord, observe that where the ingredients required to constitute a criminal offence are not made out from the bare reading of the complaint, the continuation of the criminal proceeding will constitute an abuse of process of the court, my lord. So in the light of the aforesaid judicial pronouncement, clearly crystallized that mere holding the hands of the victim would not attract the offence of section 354 IPC in its margin to this world. Just submitting, my lord, it's a common that male and female exchange pleasantry by shaking hands and hugging, embracing each other. Furthermore, there is absolutely nothing on the record to show that the accused has any intention to use the victim to satisfy his lust while holding his hand. Thus, the act of merely touching. Because at these stages, your lordship, we cannot advert into the truthfulness or wrongfulness, only whether prima facie materials. Thus, the act of merely touching a woman's hand by itself, prima facie does not constitute the offense of outraging the modesty of a woman as defined under the section 354 IPC.
Which paragraph? This is you are reading. This
This list of books, my lord. No, this
Santa
is my
Singh.
submission. But this is my submission, my lord. Page 4, my lord, of book list of books, my lord.
Yes, page 4.
Yes, my lord. Yes. This is my conclusion drawn from reading the respective judgments of 9 courts, my lord. Meghalaya and starting from Supreme Court, Naresh Aneja. Because mens rea is required now. So it is actually submitted that on a bare perusal of the averment, your lordship got it, my lord? Page 4. Page 4 of
Yes,
the list
Naresh
of.
Aneja, yes.
Yes, my lord. Page 4 of the, my lord. A list of books, my lord. Submitted that on a bare perusal of the averment mentioned the FIR and the 164 statement of the victim owner, it clearly transpired that the accused petitioner never assaulted and used any criminal force upon the said victim woman. And further, the accused has also not used any criminal force on the victim woman, intending thereby to outrage her modesty. As such, it is a fit case wherein a lordship, by applying the aforesaid test as laid down by the Honorable Apex Court in paragraph 12 of the case of Premaya, that is Prem Prakash versus State of Rajasthan, reported in AI 209. SC 351 would be pleased to hold that the accused petitioner had not committed any offence as mandated under section 354 IPC and thereby caused the impugned FIR charge sheet number 50 and order dated such taking cognizance of it and issuing process thereof, my lord. And the main judgment which I realize Naresh Aneja, my lord.
Yes.
So I should
Para 12.
Mine, yes.
12.1, yes.
I have written it on the top, my lord. The relied upon para and everything.
Yes, yes. Okay.
So with that, my lord, I lay my case, my lord. Anything reply and response
Yes.
required. Because the opposite party did not appear on her own by engaging lawyers, so she was appointed as the amicus curiae.
Lordship. Lordship, may kindly see page 41, cognizance was taken under section 354, Lordship. So may I read Lordship 354?
Yes, yes.
Assault or criminal force to woman which it intend to outrage her modesty, Lordship. Whoever assault or uses criminal force to any woman intended to outrage or knowing it to be likely that he will thereby outrage her modesty. Lordship, criminal force is defined in section 350, Lordship. May I read, Lordship, criminal force? Whoever intentionally uses force to any person without that person's consent. In this case, the petitioner has hold her hand without her consent, Lordship. And she is in her FIR, Lordship, may kindly see last part, she said that this is very uncomfortable for her. The ingredient of the 354 are there, Lordship.
Yes.
I read the FIR, Lordship, last part.
I think we have read
I
it.
have read it. Put it all.
The
Just point out which part you want to see.
last part, Lordship. I neglected thinking that it may be his way start a new beginning on the way. He began held my hand, and even while driving the cab, he kept holding my hand, and I was very uncomfortable, Lordship. Basically said that. And I did not expect this kind of behavior. He held my hand not once but twice, but many times, Lordship. Wash, Lordship.
No protest from her side.
Keep peace there. Please also, my lord, one day completed the whole investigation, my lord. In a hurried manner, just to shelve off their duty, my lord.
I think CRPC envisages in 24 hours.
No, that is the, now it is not 24, my lord, much more. So he only followed that spirit, 164 recorded, now filed the charge sheet, without reading, without applying mind, my lord. That is from the date of arrest, my lord. But when the framer, my lord, framed it, my lord, how could they perceive that within 24 hours?
Depends in England,
My lord,
maybe.
well, anything required, my lord, we are there, my lord. We have given everything to your lordship, my lord.
CAV.
দেখেনি বিছানা লিখে দেখে কি দিন কপি আসিল না এটা এই কপি দিয়েছেন দাঁড়াবো পেটিশন টাইপ করা আছে কিনা না এখানে হ্যালো উই টেক লিভ মাই লর্ড মাচো
Maybe. May I please, Lordship? This petition preferred by the husband, Lordship, is the order passed by the learned session judge, Lordship, whereby it was directed to pay maintenance 12,000 rupees per month, Lordship. Impugned order page 136, Lordship, in excerpt 14. When
Page
136, Lordship. Event page 152, Lordship. At 22 onwards, Lordship. With the same set of allegation, Lordship, she filed two cases, Lordship. First, she filed case under DB Act, Lordship. and wherein the learned additional CGM lordship allowed the case lordship, and thereafter the present petitioner filed an appeal before the learned session judge lordship, and in the appeal lordship the case was dismissed. Then lordship, with the same set of allegation, the petitioner approached under section 125 lordship, and learned additional CGM dismissed the cases. Then lordship, she filed a criminal revision before the learned session judge, and that was allowed lordship, with a direction to pay rupees 12,000 per month lordship. Now lordship, Annexure 1 lordship, page 19, it is the petition filed under DB Act lordship, 11 para lordship, page 21, para 3 and 4 lordship, with the main allegation lordship.
Page?
Page 21 is the petition filed by the respondent lordship before the learned CGM under DB Act lordship. There are 3 and 4 lordship. Page 21. There are 3 and 4 lordship. Merit lordship. That
This question on my lord, sorry for interruption. This is already set at rest, my lord. The order already passed by the learned court below in respect of DB case. Now this is also only an annexure and nothing else.
But lordship,
This is
without
only an
any reason, without any sufficient reason, if the wife leaves the husband's house lordship, she is not entitled for maintenance under section 125(4) lordship. That's why lordship. Completely false allegation lordship. It is proved from the evidence lordship. That's why I am referring. May I read lordship, paragraph 3 lordship, and 4.
Yes, I have already read it, yes.
Then
Next.
lordship, annexure 9 lordship, that is the complaint filed under 125 lordship. Annexure 9, relevant page 82 lordship. Page 82. There are 4 and 5. Page 82, there are 4 and 5. Is under section 125 lordship. Same allegation.
Yes.
Then lordship, annexure 3 lordship, PW 1 lordship, and relevant page lordship, relevant para 4 and 5, page 34 lordship. It is the evidence of the PW 1, that is the respondent lordship. Relevant para 4 and 5 lordship, page 34.
Yes.
Then lordship, page 48, it is the evidence of the PW 2 lordship. Relevant page lordship 48, para 4 and 5 lordship. See, same fact lordship is stated here. Then close part lordship. First lordship, page 48, para 4 and 5. It is the statement of the PW 2 lordship. Same thing is lordship is stated here.
All right, these are matters of evidence. If the court is
Then
to
lordship, yes.
interfere in this, then what is the
From the-
legality in the impugned order? That is what you have to point out now.
Yes, lordship. From the fact, it is clear, from the fact and evidence lordship, it is clear that the wife has left the husband house without any reason lordship.
But that aspect was considered by the learned additional session, additional CGM lordship. And that's why the 125 proceeding was dismissed. Then while
What did
the
session just say in this regard?
but lordship session just has not considered the fact 125 for lordship, considered the law lordship. That's why petition is before this honorable court lordship. And lordship, I'm referring on judgment lordship.
Where is session judge's order?
Yes, lordship, in excerpt 14 lordship. In excerpt 4136 page number. 11 para 22 onwards lordship. Page 152.
One 36.
152 lordship, 11 page lordship, para 22 onwards lordship. And it's 152.
There are 21 and 22 is the answer of this.
We've given a finding that there is nothing to show that she left of her own and that there is evidence of cruelty.
That is why lordship, but from the evidence.
My lord, paragraph number 21 of page 152, it is clear, my lord.
From the evidence lordship, it is clear that she is
21 and
voluntarily
22.
left the house lordship. Till date I am ready to live with her lordship. Let her come lordship. I am ready lordship. If your lordship comes to page 36 for moment lordship, the cross examination of the BW2 in the DB case lordship, it is clear lordship. Page lordship. Page 45 lordship.
Yes.
The cross part lordship. From middle portion lordship. I was present at the time Sangita's marriage. It was solemnized on 18/2/2017. After marriage, Sangita lived her conjugal life for 14 months. I went to Bija's house at the time of marriage. After that, I did not went there later on. I did not see any torture happened upon Sangita. I submitted my affidavit as per Sangita's instruction lordship.
But this is not regarding that torture. It is regarding what you have written in your written statement.
But
Leveling
lordship,
allegations of
yes, lordship, but
theirs and all that. That has
but
been
the fact
regarded
stated,
as cruelty.
but the fact stated in DB case as well as in the maintenance case, all totally same lordship. Totally same lordship. The same fact, exactly same lordship.
This is an independent finding. The result of two cases will be exactly same. Be other evidence. That case, you may not have stated these things in your written statement. In this case, you have.
Yes, Lordship, my written statement, Lordship. Uh, Page 89, Lordship.
Written statement where?
First, the maintenance case, Lordship. Page 89, Lordship, para 10 hours, Lordship. It's also overlooked by the learned session judge, Lordship. Para 10 and 11, Lordship. The contents of para 5 are totally false and fabricated, hence denied by the so-and-so, neither second party nor his family members ever tortured the first party in any manner. Even he loved the first party very much and was always eager to lead the conjugal life with her. But in fact, from the very first day of their marriage life, the first party showed no interest in the second party and in leading the conjugal life. Even in the very first night of their conjugal life, the first party did not allow the second party to enter into their bedroom. She slept alone, locking the door room from inside, which compelled the second party to sleep in another room. Even till 3 days of their marriage, the first party did not talk with the second party, but the second party, with utmost patience, tried to make easy the first party with him. After few months, the second party came to know that the first party has love affair with someone other, and when he asked her, she at first denied but then admitted and apologized. The second party further said so-and-so complaint, filed totally false complaint, act so-and-so in court of so-and-so. That in 11, Lordship, that in fact the first party never tried to adjust the second party as well as with his family member. The second party most of the times stayed outside home for his service, but the first party every now and then without any reasonable grounds indulged and in quarrel with the mother of the second party. Even over phone she told the second party that she could not stay in his house along with his mother, and she forced him to keep her in a rented house at Shakti Ashram. But the second party tried to convince her and stay with her mother as the physical condition of her mother was not very good. And she needed care, but she did not agree. And in the month of February 2018, she left the residence of the second party and went to her parents' house. At that time, the second party was in his place of posting, and knowing the fact, he tried to make understand the first party over telephone, but she was very adamant not to lead the conjugal life with the second party along with his mother in his residence. After that, in the month of May, Lordship, in the month of May 2018, the second party came home in leave and went to the residence of the parents of the first party to bring her back, but she denied to come back and asked him to take a house on rent at Shakti Ashram. Otherwise, she would not lead the conjugal life with the second party. The second party tried utmost to convince her, but she was adamant. Even on 31st May 2028, when the mother of the second party died, then also neither the first party nor anyone of her family member visited the house of the second party to see her for the last time. In fact, the first party was never willing to lead the conjugal life with the second party. Even after death of her mother-in-law, she did not visit. That's the condition, Lordship.
Content was driven out from the house. That is why she unable to came.
But in DB case, it could not be proved.
Unable to came. Otherwise, why a lady will not come to her husband's house?
Yes. Good.
Yes, Lordship. So without any sufficient reason, Lordship, she has left the maternal home, Lordship. As such, she is not entitled for any maintenance, Lordship, under section 125(4), Lordship. I'm citing on. Yes, Lordship. There are seven, Lordship. The second ground on which she would not be entitled to maintenance allowances is ground of her refusal to live with her husband without any sufficient reason. This also presupposes the subsistence of material relations between the parties. If the marriage subsists, the wife is under a legal and moral obligation to live with her husband and to fulfill the marital obligations. She cannot, without any sufficient reason, refuse to live with her husband, Lordship. Because he could not prove any allegation against the husband, Lordship. That's why the DB case was dismissed. With the same set of allegation, she has come to second time with a 125 proceeding, Lordship.
My lord, respondent resided with the husband 1 year, 4
Let
months.
her come, Lordship.
1
Let
year,
her
4
come.
months.
I will leave, Lordship.
And there
Let
was
him
the
direct,
complaint
Lordship.
to the left.
Let her come.
She was
I'm ready
driven
to
out.
live with her.
Now the mother-in-law is dead, you can go back.
Yes, Lordship.
After mother-in-law, when I was driven out, how can I come, your lord?
That was when mother-in-law was there.
Why she did
Lord,
not visit the mother
my lord, in my case, my lord, I have stated again and again, my lord. One paragraph, page 82, my lord, if your lordship, I have stated.
What have you stated? Question is, when she was driven out, according to you,
Yes.
mother-in-law was there or not? Mother-in-law was alive.
Mother-in-law was there by that point of time.
Yes, that is what I am saying. She
Yes,
is no longer
mother-in-law
there
was-
now. You can go back.
But unless I get information, how can I come, my lord?
Don't know she is dead.
Nobody has informed me. It was recorded. Nobody
Now
has
you-
informed me.
Now you know.
Now I know, but how can I come unless my husband is taken me?
Take her.
Yes, Lordship, I'm ready. I'm
Unless,
ready, Lordship. Let her
unless my
come.
husband, she
Tomorrow they-
she was driven
come
out from
today
the
also,
business.
I am ready.
Otherwise, she is a
her
educated
come.
lady and
See,
she
it
will
is not a matter of joke actually. It is a matter of relationship between two persons.
Yes, my lord.
If even now, as he says, he is willing to take her back. If she is willing to go back, we can still wait, give a chance.
If your lordship passed an order, I am ready to.
What order should we pass?
To unite together. I have no objection.
Can I order you to live together?
Yeah. With full responsibility. Otherwise, why I will go. And my lord, in this case, what wrong was committed by the learned session?
Let us refer it to mediation then.
Let it be. I have no objection. It is a good sign. I have no objection.
Maybe the marriage will be saved.
That may be, but Lordship, there is one thing, Lordship, the petitioner is working in BSF, Lordship. For deep, Lordship.
Let him pay the maintenance amount, my lord. There is no
So,
objection. Let
Lordship,
him pay
I
maintenance.
have
I
to
have
take
no objection.
instruction when he will get leave, Lordship. First, Lordship, it will.
Let him
You
pay
can
area
contact him-
maintenance more than
contact
3
him
lakhs.
and, no, that mediation center will give you the date. You can refer it to mediation.
Maybe, Lordship.
No problem from my, but in the meantime, my lord, at least area maintenance should be paid. Otherwise, it is of futile efforts.
Here means since when?
My lord, 3,96,000
But
rupees
Lordship,
area
so far my
as on
instruction
18/9/2025. Now another 3 months already left.
Till
3,96,000 as on.
Till that is paid, another 3 years will go. Before that, mediation will be over.
My lord, if this amount already paid, then no problem from my side.
If already paid, is it paid or not?
Not a single pie paid as on today.
So far, some amount has been paid, Lordship.
No, not a single pie so far,
But
my
Lordship-
information, my lord.
Yes, Lordship. Some amount has been paid, Lordship.
Give receipt. Show the evidence.
He's saying that so that she doesn't have to pay.
My lord, my intention is to live together with my husband.
All right.
That's fine, Lordship. Then
Till today, I am
matter will be
willing
referred
to
to
reside with my husband.
mediation center. If she is willing, then I am also willing.
I have nothing to say, but my pending area should be paid first. I suffered a lot.
Who, you or your client?
My client, that means
Due to non-payment.
yes. From the last from 2023, my lord, I am suffering. My client is suffering.
Even if we pass any order for maintenance, by the time that is satisfied, then mediation will already be over by then.
It's up to your lordship to decide. I leave it to your lordship. But at least unless the area payment is made, how can I do? She is now a destitute.
Right, pending mediation, you have to pay something.
Lordship, I will
Some
instruct
amount
my-
you have to pay.
I will instruct.
At least 50% should be paid, my lord. For the ends of justice, I am submitting before your lordship.
That may be possible, may not be possible 50%, Lordship, but something will.
Something,
I'm assuring
it
you.
is not a bonanza. You will enjoy and I will suffer.
No, I am not enjoying. I have lost my marital life. Just for it.
I'm still waiting.
I'm not enjoying.
Pay 6 months worth of maintenance. Pending mediation.
But Lordship, as per my instruction, some amount has been paid, but my friend has been saying that nothing has been paid.
So far,
in this regard,
my information, my lord. Recently, if it is
if
given, I
it
do not know.
already for 6 months already paid, Lordship, then I will not pay a single penny, Lordship.
50%
already
should
paid,
pay.
Lordship.
Otherwise, let this matter be
Because she is misleading this honorable court.
Let you get your instruction then. What is paid? He won't tell you. You get from your client what has been paid. If it is paid,
Yes.
it must be by way of some
Yes, Lordship. Confirm.
electronic transaction or something. You
I'll confirm it, Lordship.
be able to provide proof.
February, my lord. Your lordship already heard. And if not paid, then my lord,
Yes, Lordship, on that occasion, Lordship, I will also inform this honorable court when he can come on leave.
Hard, learn it. Thanked. It appears that there are some settlement. Here whether been paid as maintenance. As specific instruction is not available with the learned counsel, their respective clients. Is the matter again on 5th of February. Is that the instructions will be obtained is before the court. Is the court as and he would be available for mediation. Matter is referred